Argument next in case 24-351, United States Postal Service versus Konan. Mr. Liu?
Mr. Chief Justice, and may it please the Court. The postal exception to the Federal Tort Claims Act preserves the United States immunity for any claim arising out of the loss, miscarriage, or negligent transmission of mail. Respondent alleges that her mail didn't reach its destination because postal employees intentionally withheld the mail and returned it to sender. That allegation falls within the postal exception for two reasons. First, respondent alleges a miscarriage of mail. When Congress enacted the FTCA in 1946, miscarriage had a specific meaning in the mail context. It meant the failure of something sent to arrive or to be carried properly. Indeed, pre-FTCA decisions used miscarriage to describe the facts alleged here, mail that wasn't delivered because it was intentionally returned to sender. Second, respondent alleges the loss of mail. Her own complaint uses the word loss, and she doesn't dispute that she alleges a loss for purposes of the FTCA's sovereign immunity waiver. There's no reason to give loss a different meaning in the postal exception. In fact, the presumption of consistent usage, contemporaneous dictionaries, and pre-FTCA decisions all support reading loss to have the same meaning. Respondent's claims therefore satisfy two out of the postal exception's three prongs, which is no surprise given that loss and miscarriage were understood to be overlapping terms when Congress enacted the FTCA. Respondent's contrary view that her claims satisfy none of the exception's prongs can't be reconciled with that historical understanding or with Congress's belt and suspenders approach to protecting postal operations from disruptive damages suits. I welcome the Court's questions.
Mr. Liu, what should we do if we find ourselves in equipoise on this?
Well, I would hope I would hope that there were enough votes that there was a judgment as to whether the facts here fall within the exception, even if there's some disagreement about which particular prong it fell in, and that bottom line judgment would control the disposition.
Should we give any special weight because this is a waiver of sovereign immunity?
Well, this Court in Dolan rejected the notion that the exception should be interpreted differently because it implicates a waiver of sovereign immunity. We haven't taken issue with that here. We do think if there is a tiebreaker sort of canon at play, it is the canon that rules that govern jurisdictional issues, and sovereign immunity, of course, is a jurisdictional issue, that those rules should be made as simple as possible. And in our view, we've submitted the most simple rule. It's simply the rule this Court articulated on page 489 of Dolan, which is that injuries arising directly or consequentially from the mail not arriving at all, or from the mail arriving late or damaged or to the wrong address, fails to get to the right address, that those are the types of injuries that are covered, and it doesn't extend any further.
But loss doesn't typically convey, I mean, technically I suppose it can, malfeasance involved. I mean, if I say I lost my car, people aren't going to think somebody stole his car. They're going to think I forgot where it was or something like that. In other words, it doesn't say something bad has happened other than, your own, in fact of paying attention to something. If somebody said I lost the mail, I would not think necessarily, I wouldn't think right away somebody stole it.
Well, our submission, Mr. Chief Justice, isn't that loss necessarily encompasses malfeasance or intentional misconduct, just that it can refer to it. And we know it can refer to both intentional or unintentional conduct because, for one thing, Congress used it that way. In Section 1346b1, which is the FTCA's principal provision, the provision that respondent has to get through just to be able to assert a claim, Congress used the phrase loss of property and then made clear that those losses encompass deprivations caused intentionally or negligently by federal employees.
But, Mr. Liu, if you agree that loss doesn't generally refer to intentional actions, and as the Chief Justice said, generally doesn't refer to them, but we all admit it can, what do we do with negligent transmission? Why bother with that? If loss covers that, there's a lot of surplusage in your reading of this statute. Not just with loss, but with miscarriage, too, for that matter. So help me out.
Yeah, so I'm happy to go through it. With respect to your specific question about any overlap between loss and negligent transmission, we don't think there's any overlap there. We think loss covers any deprivation, outright deprivation of mail, just I didn't get the mail. And negligent transmission covers I did get the mail, but I got it late or I got it damaged. So we don't think there's any overlap there. But you're right that there is overlap in other parts of it.
Miscarriage.
Miscarriage. And we think what Congress presumably was thinking.
Maybe with negligent transmission, too, if transmission might include something more than it arrived, if it means it didn't arrive through negligence. It wasn't fully transmitted properly.
That's why we need.
So there is still surplusage there too, honestly, I think, but certainly with miscarriage.
Well, the way
if
I
we
would
have any presumptions about statutory interpretation, it's generally to try and give effect to each of these words, right?
That's right, but I think in this case, the court has said that's not the be-all, end-all, and I think in this case it would be wrong to apply the surplusage canon here because we know what the historical meanings of these words were in 1946. Judicial decisions, like the opinion by Judge Cardozo on the New York Court of Appeals, use some of these terms interchangeably. He referred.
I'll let you go with this one, though. If we're going to go back to 1946, there was a big distinction between, between miscarriage and detention, right? And this doesn't strike me as a miscarriage case in 1946. It strikes me as a detention case in 1946. If we're going to go back in, we should.
Yeah.
It's an important case, but this doesn't strike me as miscarriage. And if we're going to go to 1946 under your regulations, it's a detention case.
Well, two responses to that. I think just as a definitional matter, there's a difference between miscarriage and detention. Miscarriage implies that something bad happened to the male. Detention might be a perfectly appropriate thing to do to the male. But the second point I'd make, and this goes to the historical usage, is that there are cases, and we cite them on page 7 of our reply brief, where mail getting stuck at the post office, i.e. being detained at the post office, is referred to a miscarriage. That's the Cardozo case. There, the mail got stuck behind a radiator at the post office. And the way Judge Cardozo described it was that the checks in the mail had miscarried for that reason.
Mr. Liu, Justice Gorsuch raises an important point about the surplusage. On the other hand, I guess Congress often drafts things to be redundant and overlap, and ordinary people communicate that way, particularly when they're giving instructions too. So both, Congress would much rather have overlap than leave a hole.
Exactly. And I think there are two strong
But how do we know? But at the same time, we do have the surplusage canon. I mean, the Eskridge book says it's often unrealistic. The Scalia book says, sometimes drafters do repeat themselves and do include words that add nothing of substance. And I think that's right. But how do we tell?
Yeah. I think here there are three clues as to why Congress embraced a belt and suspenders approach. One is the historical, ordinary meaning understanding of these terms. If you look at the dictionaries and the dictionaries that existed in 1946, these are overlapping terms, and Congress included them in the statute anyway. The second point I'd point to is the way Congress approached the intentional tort exception, which is in 2680H. There, Congress used overlapping terms. It included both deceit and misrepresentation, even though, as this Court pointed out in footnote 16 of Newstat, deceit encompassed all kinds of misrepresentation. That was the understanding of the restatement first of torts. And the last thing I'd point to is the importance that Congress attached to the postal exception. This was not an afterthought exception. This was an exception that was in the earliest drafts of the FTCA. It's the very second exception listed. And you can understand why in 1946, when writing a letter was the only way to communicate in writing, that Congress would have wanted to protect that postal function.
Counsel, let's assume that your definition of miscarriage, because this is what I'm assuming, you define it as a failure to carry the mail properly. Then loss, to me, and negligent transmission are redundant and useless. Congress knew in the customs duties, custom handling exception, which we looked at in Kawash, how to write a very broad exception that covered everything, intentional and unintentional conduct, but it didn't. It chose very particular words here. And so let me give you some examples I'm troubled by, why they would have imagined that intentional malfeasance would be accepted by this. By the way, I think intentional malfeasance often will be covered by a different exception in the FTCA. In many, some are discretionary, in others, they're outside the scope of employment. There's a lot of other exceptions that cover a lot of the intentional misconduct. But I'm troubled by this. A postal worker refuses to deliver any mail-in ballots from county he associates with a certain political view. Or on election day, the postal worker postmarks some ballots but not others because he's favoring one side or another. This is a miscarriage, isn't it?
Yes.
Okay, so that's exempted. What about when a postal employee writes harassing messages on an individual's piece of mail every day that he delivers it? You are a thief, you're a baby killer, whatever other harassing messages you want. That's a miscarriage. He's not carrying the mail properly.
I'm struggling with that because there's not really anything bad that's happened to the mail in the sense that the mail is getting there on time, it's getting there, the contents are not damaged, it's getting to the right address. But he's not carrying it properly, is he? Well, I think when it's being carried properly, it's referring to the duty of carriage that the post office has to both the sender and the recipient. And that includes not letting the mail intentionally be damaged. You got to. Yeah, I think that would be the key question in that hypothetical. Whether you can count that as damage. How about when a postal employee refuses to take a person's mail in a rural community? There's a post office there. He's supposed to do it, but he forces her to drive 30 minutes one way to a post office who will take her mail. If it's a situation where the sender has dropped off the mail and the post office... Don't qualify it. He just doesn't like this person. Oh, no, we don't. If the mail hasn't entered the mail system... Well, it's there. No, he's refusing to take it to her. That's a miscarriage, according to your definition. I don't think so, because I think this implicates the line that this court drew. Counsel, you're fighting the hypotheticals because you recognize, I think, that inherent in using the word negligent transmission, there is a sense that Congress is using this as a verb to start with, and that Congress is looking at these situations in their generally accepted terms. As Justice Gorsuch said, generally we think of loss as negligence. Miscarriage, in all the cases you cite, they all involved non-intentional conduct, except for one, which was a case 50 years before, which really didn't have to do with miscarriage. It was a claim between newspapers, or a newspaper claiming that the post office should have selected it to transmit a message and not someone else. And so even in that case, it wasn't really a miscarriage of the advertisement. It was a failure to deal case. So I guess I'm having a problem with your starting proposition, which is that these terms have to encompass both intentional and or negligent conduct. Yeah, so with the unintentional line, I would make three quick points. One is that if you look at the traditional legal authorities, we look at the evidence of common usage at the time of 1946, None of those authorities draw a line between intentional and unintentional. That's true of the dictionaries. That's true of the decisions. We said on page 9 a number of decisions that used miscarriage intentionally to refer to intentional conduct. Later in our reply brief, we have examples
all of those cases could be distinguished. Do you lose?
I don't think so. I mean, we cite a decision involving loss that involves a postal employee stealing the mail. I can't think of anything more willful than that.
Well, that would be outside the scope of his duties, so that would be exempted under a different exemption.
Well, but I think it still goes to what the ordinary meaning of loss was at the time. Maybe another part of the FTCA would kick it out, but our point is that loss had a settled historical meaning, and it covered intentional conduct.
So, Mr. Liu, I mean, this is loss in a particular context. So there are 3 things, basically, that the Postal Service can do to your letters that we're not going to allow you to sue about. So here are the 3 things. They can negligently transmit your letters, and we're not going to allow you to sue about that. Or they can lose your letters. Lose your letters there, definitely not intentional. It's like you lost your keys, you lost your pen, they lost your letters. We're not going to allow you to sue about that. And then there's this miscarriage word that's stuck in the middle of them that's kind of like, ooh, what does that mean? They miscarried your letters. It seems kind of a weird word. But I think I agree with you when you said these are supposed to be overlapping and it's not a big deal if there's some redundancy here. I think that this is, if you look at this statement, it's kind of words are known by the company they keep. On one side, they're losing your letters. On the other side, they're negligently transmitting your letters. And on the other side, they're miscarrying your letters. And miscarrying basically has the same kind of meaning, which is they did something mistakenly with respect to your letters. And that's the way that seems most natural to me to read this sentence.
And I would say a few things in response. One is, I think that Nossiter intuition works only if you, as I think your premise of your question did, buy in that loss refers only to unintentional conduct. We think that contradicts the meaning of loss in the FTCA's sovereign immunity waiver. And
I don't think that that's an argument that works, because if you look at the sovereign immunity waiver, it's using loss in an entirely different way and context. It says the district court shall have jurisdiction over claims for injury or loss of property or personal injury or death. So their loss is functioning as just like one of a number of different kinds of harms that a person can suffer and bring suit about. But this is like losing your mail. That's what this is about. And when you lose your mail, you don't like destroy your mail or tear up your mail or purposefully put them in the trash chute. You lost your mail. They lost your mail. The Postal Service lost your mail. Sorry, you can't sue about that.
But I think that setup reveals one of the debates is who lost what. I think it is quite natural to say that Respondent lost her mail. Indeed, she uses that same phraseology.
This has got to be, Mr. Liu, that the post office is doing these things. The post office is negligently transmitted, the post office is miscarrying, and the post office is losing your mail. And notwithstanding that the post office did all those things to you, you can't sue.
I don't think there's a reason to shift perspective from the waiver to the exception. I think
these are 3 parallel terms. You're shifting perspective from loss as opposed to miscarriage or negligent transmission. These 3 terms are the terms that have to be read in parallel form. The post office is doing these 3 things to your mail, and you can't sue about any of them.
Well, Your Honor, I think the better way to read them is that these are 3 harms. Just as in the waiver, loss is paired with injury in the waiver. Loss is paired here with 2 other types of more specific terms that describe injury to mail, i.e. miscarriage and negligent transmission. Your Honor suggested that if you translate them into verbs, there's some parallel structure. That's actually not true. I mean, no one in 1946 would have said the government miscarried the mail. The mail never took the government or the postal worker as its subject. The mail, when miscarry is used as a verb, it takes the mail as its subject.
Okay, but
and that's because, for a reason Respondent points out on footnote 19 of her brief, miscarriage is an intransitive verb, just as you wouldn't say the government arrived the mail, so too you wouldn't say the government miscarried it.
I'm sorry. Go ahead.
And so there really is nothing to be gained from trying to convert these nouns into verbs. There is no single consistent way.
So if I accept that textual reading, and I also even start by accepting your argument that the Postal Service or the postal exception immunizes intentionally caused losses and miscarriages, those harms happening to people could be intentional. Let's say I start there. I guess I don't understand why all of Ms. Konan's claims here would be immunized under that exception. She has 4 claims here, only potentially one of which, it seems to me, even relates to the failure of her mail to arrive as the gravamen of her claim. The way we think about torts is people are bringing claims alleging that wrongful conduct or, negligent conduct by the defendant is a breach of a duty of care that has harmed them or breached a duty that harmed them. And I guess what I'm suggesting is that she's got claims here that really aren't about the loss of the mail, right? So they're not keyed to the failure of her mail to arrive. So the intentional infliction of emotional distress claim, for example, seems related to her claim that postal employees carried out a campaign of racial harassment with respect to how they treated her mail. And yes, we have the "my mail never arrived" is an allegation, but that's not her claim when it comes to intentional infliction of emotional distress. So I'm wondering why, even if you're right, she doesn't get to go forward on at least that claim.
So we think this is an issue that can be left on remand. The principle we're trying to vindicate here is simply the legal standard, and I don't think the court really needs to.
So you're not saying that Postal Service knocks out her IIED claim?
We're not asking the court to decide that. I think that's an issue that can be left for remand. On remand, we will make that argument, and we'll also make the argument that Respondent has forfeited any contention.
All right. So going to the particular argument of a claim, assuming she has a claim in her complaint that actually is about the mail not arriving, as opposed to her IIED claim or her tortious interference claim, those seem like they're talking about other things. I guess I go back to Justice Sotomayor's suggestion that your argument indicates that Congress would have intended to immunize a Postal Service worker who tears up a person's rent check or, Social Security check in front of them on their porch right there, intentionally. So it didn't, it doesn't get delivered. And you're saying, yes, that's in the exception.
Yeah, and I don't think that should come as a surprise. Congress immunized all sorts of intentional conduct in the FTCA's exception. So in the intentional tort exception, it immunized assault and battery and misrepresentation.
Yeah, but there has to be a reason that makes sense. And so the whole thing is Congress, the FTCA is Congress authorizing tort claims to be brought against the government. This is an exception, and so the exception kind of has to make sense. And I guess what I'm trying to figure out is why Congress would have we understand why Congress would have wanted to immunize negligent loss of the mail, miscarriage. First of all, that happens all the time.
Right.
And you could imagine a rational Congress saying we just can't run a post office if everybody whose mail, catalog didn't get delivered can sue us. So we're not going to allow that. That makes perfect sense. What is hard to get one's mind around is in a statute in which Congress was authorizing tort liability, that a classic scenario in which the mail is actually being intentionally damaged, lost, not delivered, they also meant to take that off the table.
Two points. One is that Respondent's rule is so broad in how it identifies intentional that it would encompass not just the willfully malicious hypos that Your Honor gave, but also routine application of postal regulations. Every day, the Postal Service intentionally withholds mail, either because it can't identify the addressee, because it thinks a residence is vacant, because it thinks the mail—
I understand, but the question is which overbroad rule are we going to go with? You're saying because that's the case, we should allow the tear-up scenario to occur, that Congress could have wanted that, and I guess I don't understand why.
That gets to my next point, which I think as to the egregiously willful conduct, Congress, if I may finish, Mr. Chief Justice, Congress made the same judgment in the postal exception as it did in the intentional tort exception, and indeed some of the other exceptions that are far broader than the postal exception, which is that these damages suits aren't a good way for identifying who the bad actors are. It may well be that there are allegations that something willfully wrong happened. We're going to want to present evidence to refute that. It's going to be burdensome to the Postal Service and to other parts of the government, and Congress didn't think this was the right way to go about identifying those cases.
Thank you, Counsel. Justice Thomas? Justice Alito?
Well, as for the possible reason for immunizing intentional conduct, the answer that I took from your brief was that allowing that would open the door to too many lawsuits, and it would undermine the immunization for the negligent transmission of the mail. So I don't get my Christmas cards until 3 weeks after Christmas, and I can't sue on the ground that it's negligent. But if I say, well, the delivery person doesn't like me for one reason or another, it was intentional, and then I'm in court.
Yeah, no, that's true. I mean, we're talking about over 300 million pieces of mail delivered a day. We get over 300,000 complaints about the conduct of letter carriers a year. If even 1% of those complaints results in a lawsuit, the number of suits that the Postal Service faces each year is going to quadruple. And as Your Honor's question suggests, things like intent are easy to allege and hard to disprove. It may well be at the end of the day we're going to be able to show that some alleged instance of intentional misconduct was indeed just a mistake. But at that point, we've defeated the purpose of having an immunity from suit, which was to relieve the Postal Service of the burden of having to take postal workers away from their day-to-day jobs and force them to become witnesses in court.
Justice Sotomayor?
Counsel, you are forgetting, however, that there's a requirement of good faith allegations. Merely saying someone dislikes me is not enough, correct?
That's right. And I think—
Now, putting that aside, so much else is, as I pointed out, would be exempted by other provisions, correct?
I don't think a lot of any of the other provisions is really going to address this problem, especially the Congress's preference for these suits to be, for this immunity to be an immunity from suit.
I go back to, they could have said very simply, anything having to do with mail delivery is out. But they use something different than they did in customs.
Oh, but to be clear, our position isn't that the exception should be read more broadly than the court read it in Dolan. The court in Dolan limited the exception.
But what else wouldn't be covered? Even in Dolan, I'm not sure how, accepting your definition of miscarriage, we could have ruled the way we did and placed any limitation. Because placing a package on the porch, not near the door, or on a step, is a failure to properly carry the mail. You're supposed to deliver to the recipients and not to a porch step.
No, we read Dolan to say that these three terms, and the court described them as harms on page 490, these three harms are harms in the sense that they are bad things that happen to the mail. And I think what the line the court was drawing in Dolan is that if you're alleging a bad thing that happens to someone around the mail or to something else, you're outside the scope of the exception. But what's clearly within the exception are bad things that happen to mail. It doesn't arrive, or it arrives, but it's damaged or it's late. And all we're saying is that's our simple rule. There's no more fine-grained analysis about why the mail didn't get there.
Thank you.
Justice Kagan? Justice Gorsuch?
Briefly, not to belabor the point, Mr. Liu, but Just following up on Justice Sotomayor's point, would these three terms, as you read them, cover the waterfront of anything having to do with deliver the mail? So the government is effectively totally immunized, intentional, non-intentional actions in the delivery of the mail.
It would immunize us only as to bad things that happen to the mail, not as to auto accidents.
No, I understand your Dolan point, but putting aside the Dolan point, in the delivery of mail, it would immunize everything.
Correct.
Okay.
So long as we're not including in delivery what the court rejected in Dolan.
Dolan, yeah, okay. And isn't it an odd way to do it, though, to have three terms rather than just to say that?
I don't think so, because these were the terms that was in the vocabulary in 1946. And if you compare the terms here to the terms of the waiver, all Congress is doing is coming up with two words, miscarriage and negligent transmission, to describe injury to mail. It's covered loss of mail by using the same word, loss. And now
I understand the point, and thank you. Appreciate it.
Justice Kavanaugh?
On Dolan, it's got a pretty straightforward sentence summarizing what it thought the rule would be. I mean, deviating from that, response should we, what concerns would you have about deviating from what the court said in 2006?
Well, I think it would be a sea change in how the government has approached the postal exception from the very outset. The way the court described it in Dolan was to capture bad things that happen to mail and to leave the United States open to liability for other things, including slip and falls and auto accidents. And when you look at the composition of the cases that the Postal Service faces each year, it's about 900 cases. About 800 of them are about auto accidents, and another 70 or so are about slip and falls. And then there's a smaller category of other. But I think if you look at that composition of cases, you would say the postal exception is working exactly how Congress intended. The main core function that I was discussing with Justice Gorsuch is protected. And these other types of injuries that aren't about the bad things happening to the mail are allowed to go forward in these lawsuits. I think if you accept Respondent's rule, which would be to disregard the rule articulated in Dolan, we're into a universe, as Justice Alito suggested, where we're going to be faced with, I think, a ton of suits about mail. And they're not all going to be bad faith. They're going to be plaintiffs who simply aren't in a position to know what happened to their mail, and they're just not going to give the government the benefit of the doubt. They're going to infer that their mail didn't arrive because of a rude comment that they heard or what have you, and that's going to lead to discovery, a trial, on what actually happened to that mail, which we think is going to be quite burdensome.
Thank you.
Justice Barrett? Justice Jackson?
In the cases that you just described, though, isn't that the work of Iqbal and Twombly in terms of the government's response? I mean, if a plaintiff is just saying the claim is my mail didn't arrive, that was harmful to me, I'm suing the post office, that seems to be heartland postal exception. I don't think anybody disagrees with that. But if there's some allegation about intent with respect to the mails not arriving, I would think there would have to be plausible allegations that there was some intent on the part of the post office and it would delivering person, and surely the government would not concede to go to trial over that issue just because the person says in their complaint, my postal worker intended not to deliver it to me.
That's true. We certainly would file a motion to dismiss.
So the real worry is in these, I would assume, rare cases. I mean, I can't imagine that the postal workers are, actually, actively, intentionally withholding people's mail on a regular basis. So I just don't know how many cases we're talking about here.
That's part of the point I was making before. As a matter of routine, the Postal Service intentionally withholds people's mail for all sorts of legitimate reasons.
Well, that's an easy defense then. I mean, there it is. And it's not intentional in the sense of a harm.
It's an easy defense once we've had discovery. It's not an easy defense when we're trying to fight off a complaint, because from the outside, that intentional withholding can easily be mistaken.
All right. Let me ask you about a hypothetical, because I'm looking at mere miscarriage definition, and you define miscarriage as the failure of the mail to arrive, and you say even intentionally caused failures to arrive would be covered. So let's say we have a mother who regularly writes her son, who's in the military, and a postal employee maliciously, intentionally, and repeatedly returns her mail as undeliverable and stamps deceased on it. Could she sue for intentional infliction of emotional distress under those circumstances? You're saying your case doesn't cover intentional infliction of emotional distress.
Right. I think the postal exception would deem that as a miscarriage of mail. And in fact, there are cases, believe it or not, from 1946 and before, where an erroneous message is delivered, like deceased.
Yeah.
And the plaintiff wants to recover consequential damages for that. And I think that is the heartland of what...
Even though she also meets the elements of IIED under those circumstances, that this is an extreme and outrageous intentional act that causes her emotional distress, you're saying this, even though that's a separate claim, it's not really about what happened to the mail. You're saying that would be covered? That's what I'm worried about
right.
with Ms.
Well,
Konan.
This implicates a different part of the postal exception, and the language of the postal exception begins any claim arising out of the loss, miscarriage, or negligent transmission. And if the damages, the injuries being asserted, the emotional distress arises out of...
Yeah, but I think you would have a Dolan problem if you did this. I'll figure it out. Thank you.
Okay. Thank you.
Thank you, counsel. Ms. Anand?
Mr. Chief Justice, and may it please the Court. 3 things I want to highlight about the government's presentation. First, they did not dispute that no ordinary speaker of English would ever say, Rojas lost Ms. Conan's mail. Now, they point to 1346B, that is specifically worded differently. The question there is, did the government employee cause the loss? That's not how 2680B is worded. Second, the government has produced exactly 0 examples, no cases, no books, no newspaper articles, of miscarriage of mail being used by an everyday speaker of English to describe wrongful conduct on the part of the postal worker. That is, postal workers choosing to put the package in the wrong place. Not just intentional in the sense of, I put it on the doorstep, it didn't fall out of my bag, but I thought it was the right doorstep, right? We've never said, the Fifth Circuit's never said, no one has ever said that that is not a miscarriage, but in the sense of wrongful, which is our test for miscarriage. Third, my friend didn't dispute that on the government's reading, the term miscarriage renders both the term loss and the term negligent transmission entirely superfluous. So he says belt and suspenders. This is like not just 2 terms that have some overlap, but it's like belt and belt buckle. They're 2 terms that are completely overlapping. And even if we interpreted statutes that way, the government story for why Congress would do this makes no sense, right? If Congress is worried about miscarriage somehow being under-inclusive, it's worried about miscarriage only covering the negligent stuff, right? We give an unbroken string of examples from Henry VIII, negligence fit for a fool to fall by, to romance novels, to cases. Everyday speakers of English use miscarriage to refer to negligent conduct. And so if you wanted to belt and suspenders miscarriage, the term you add in is not negligent transmission. It's something to do with wrongful conduct. I welcome the Court's questions.
What do you do with Mr. Liu's argument that the waiver of immunity did not include bad things that happened to the mail? He said that generally, and that Dolan, because it wasn't about bad things happening to the mail, was outside the waiver of immunity.
So I think that's just
was included in the waiver.
I understand.
Yeah.
Thank you, Justice Thomas. So I think that's just an overreading of Dolan. So the sentence says that he points to says something like, as a general rule, these sorts of damages don't lie. It's using that hedging language because, again, as a general rule, we're talking about good faith mistakes. We're not talking about the rare instance where a postal worker is using the mail to effectuate harassment on somebody. So I think even taking that sentence of Dolan at face value, right, wrongful conduct was not before the court in Dolan, but even assuming it was covering that, I think that's what the phrase the general rule is doing. And I suppose I would say that feels passing strange given the rest of the statute. And its emphasis on kind of specifically carving out property-related torts. So, for instance, 2680H, the so-called intentional tort exception, conspicuously omits conversion and trespass, the two property torts. And so I think what my friend on the other side is saying is no one in the federal government can engage in conversion and be exempt from, and have the United States be exempt from liability, except for postal workers.
Is there a long history of Federal Tort Claims Act suits about the mail itself, delivery, non-delivery laws?
So there are some cases. We'll note that, kind of in response to Justice Jackson's question, most of those don't even get into court under 1346B. If you just say, my package doesn't show up, it gets kicked out of court because you don't even plausibly allege negligence, let alone wrongful conduct, right?
But you would think that with 300 million pieces of mail per day, you would have a significant number of suits that do involve this level of harm.
So I think you may have some number of suits that involve this level of harm, meaning enough to prompt someone to go to court and sue, but not that involve wrongful conduct within the scope of employment, right? That's a very narrow needle to thread. Think about what Ms. Konan alleged here, right? 2 years of non-delivery, not just a one-off package. She's filed administrative complaint after administrative complaint. She can say, look, every single one of my neighbors is getting mail. She says, when you found out I own this other property, mail stopped getting delivered there. She's got all this other kind of circumstantial evidence that doesn't have to do with the mail delivery. Those sorts of allegations, I think, will be rare. And, you know, remember, the government came before you in Dolan and said, if you rule for Petitioner, frivolous claims will inundate the Postal Service. A decade later, they're coming and saying, actually, the postal exception is working just as it should. And so I'd be a little bit hesitant to believe those claims.
Ms. Anand, I think I would really like to hear you address the presumption of consistent usage point in the waiver and the exception, because I think that's a harder argument for you. Because when you describe loss of property, loss of mail, whatever, as the kind of damage, then it can cover intentional and negligent torts. Now, you handle that in your brief, but I would just like to hear you talk about it a little bit more, because I think that is one of the hard parts of your argument.
Sure. So we don't think the presumption applies, and if it applies, it's overcome. So we don't think it applies because that presumption is where two words are being used in the same sense about the scope, right? So interest in the Internal Revenue Code. If it's talking about the stuff you get when you leave your money in the bank, in both places it must cover compound interest, or in neither place. But that doesn't mean that in the Internal Revenue Code, someone can't use interest to mean, you know, present interest in an estate, right, a claim or entitlement. The presumption of consistent usage says if both terms are being used in the same sense, then they cover the same terrain. Here we submit that it's clear that loss in 1346B is being used in a different sense, the deprivation sense, than in 2680B. And our kind of three textual clues for that. The first is that in 1346B, there's a specific reference to wrongful conduct on the part of the government employee. Second, the sentence is structured differently, right? It's asking, did the government employee cause the plaintiff to lose property, not just if the government employee lost property. And third, as the government itself acknowledges on page 11 of its reply, loss of property is something of a term of art, and when used that way, loss of property, loss invariably means deprivation.
Your reading of that sentence from Dolan to Justice Thomas, I thought was a bit aggressive on the on the general rule. I mean, the court was there specifically distinguishing the general rule from the, like, having a case-by-case determination. I thought it was articulating a general rule, but that would apply across the board. But more importantly, kind of statutory stare decisis, even if that doesn't formally apply, just we set forth the rule and Congress hasn't changed it. And this would come, I think, as a little bit of a surprise to Congress, which would probably have to address it pretty quickly.
So let me take each in turn, Dolan, and then why I don't think this is a surprise to Congress. So on Dolan, you know, that sentence has a lot of hedging language, right? It also says we think it more likely that Congress intended to remain immunity. And so even if you think the court was even contemplating wrongful conduct, right, I think that hedging language does a lot of work. And if you're going to take that sentence in Dolan and say it was thinking of kind of all cases, I think you also have to take the part of Dolan where they say loss is destroyed or misplaced and miscarriage is delivery to the wrong address, neither of which we fall into. On the Congress would be surprised point, I don't think so. Again, Congress specifically did not put conversion, for instance, in the FTCA's waiver provision. Every other kind of intentional tort, assault, battery, libel, slander, all that stuff, there's an exception for. There's no exception for conversion. And so I think Congress would actually be surprised in the other direction if this court were to say conversion, liability if anyone else does it, but not if the Postal Service does it.
So, Ms. Anand, I guess I'd like to get your thoughts on the theory that I shared with Mr. Liu, which is that in the context of a broad statute that is authorizing tort claims against the government, could it be that what Congress was actually doing with the postal exception was just immunizing the Postal Service for liability for a particular claim? If your tort claim has as its gravamen the loss, miscarriage, or negligent transmission of mail, I'm seeking damages because that happened to my mail, that's out, says Congress. This is my theory. But anything else that you are saying, even though it evolves perhaps as an allegation that those things happened, if your claim is not that, then that's in. I kind of thought that's what Dolan was doing. Because in Dolan, I guess there was an allegation that there was the negligent transmission of mail in the sense that it was put on the step in the wrong place. And if she had just come in with no step in, and just said the gravamen of my tort claim, the reason why they breached a duty and did something wrong was because they negligently transmitted my mail, maybe that's out. But Dolan says, no, her claim was really a slip and fall claim. It's a different kind of tort. And so if that's the theory, I'm asking you, is Ms. Konan she has 4 claims. Are they all making the kind of, I'm suing you because you've lost, miscarried, or negligently transmitted my mail claim?
No, Your Honor. 3 of the 4 certainly aren't. Conversion, maybe, though, as I've explained, I think it's a very weird result if you say that conversion falls out. And, as we pointed out at the bio stage, that makes this a very strange case to think about the meaning of loss and miscarriage, because, again, the gravamen of the harm here is, as you note, the kind of campaign of racial harassment.
Which fits, it seems, in the tort. There are tort elements here for intentional infliction of emotional distress that is just the defendant acted intentionally or recklessly, the conduct was extreme and outrageous, and the actions caused the plaintiff severe emotional distress.
That's right, and we think so too with our nuisance claim, and so too with our intentional interference with prospective economic relations. Now, I do want to say, I think that our conversion claim goes forward as well, because again, I think at the point where the government doesn't give you any examples of an ordinary speaker of English, I'm happy to address the Reply 9 examples. Justice Sotomayor, I don't even think Foster is such an example, the one case you pointed to, where they've given you no examples of an ordinary speaker of English saying miscarriage of mail and meaning the postal worker did something wrong. I don't see how you can decide that our conversion claim doesn't go forward as well.
If miscarriage is, I'm sorry.
Go ahead.
Sure. No. Go ahead.
All right. I wanted to shift from miscarriage to loss. And miscarriage is more a term of art. But it's not clear to me why a claim arising out of the loss of property cannot include a loss that results from intentional conduct. That's just not the way the term is normally used. A claim arising out of a loss does not have to involve property that has been lost in the sense that it can't be found. It just means that there's been a deprivation in the value of the property, right? I can submit, suppose vandals set my car on fire and I submit a claim to my insurance company. That is a claim arising out of the loss of my car. Even though I know where my car is, it's in front of my house, but it's a burned out Hulk, right?
Yes, Your Honor, but we would never say, and this is Justice Kagan's point, that the vandals lost your car, right? And that's the way that the sort of whole statute is structured.
It doesn't. It says it doesn't talk about what somebody has done. It talks about the consequences of something, which is any claim arising out of the loss.
So I think that this is sort of consistent throughout the statute. It's not just that you have to prove an assault happened in the abstract. You have to prove the government assaulted you, right? And so here it's the government lost your mail. Now, even if you don't agree with me on that, I think if you agree with me on miscarriage, that resolves the question. So that is, even if in some settings loss covers wrongful conduct, I don't think we have any story for why Congress would say wrongful conduct not counted under miscarriage, wrongful conduct not counted under negligent transmission.
Well, that's your surplusage argument, and the surplusage canon is of value, but it's not the way Congress always writes statutes. It's not the way people always talk. So it's valuable, but it's worth only so much. But I'm really troubled by how you extract from how you read into the phrase any claim arising out of a loss to exclude intentional conduct.
So just to clarify, I just want to make clear that's not actually our superfluity argument. What I'm saying is if you accept our miscarriage mens rea argument, then I think you've got you either have to accept that loss is limited to negligent conduct, or you've got a situation where, okay, postal worker takes a hammer to a package. Scenario 1, he just breaks off the handle of the mug. Scenario 2, he totally shatters the mug. Scenario 1, the government says that's not a loss. He just broke off the handle of the mug. And so it's one of the other two terms, so wrongful conduct, and so therefore it's not immunized.
Well,
right?
It's a different question about whether the loss of the mail means the loss of all value of the mail or a diminution in the value.
That's right, but Congress could not have wanted liability to turn on that fine a distinction. And if you say loss, but only loss covers wrongful conduct, right? Miscarriage, negligent transmission exclude wrongful conduct. Then at that point what you're saying is Congress wanted liability to turn in a case involving wrongful conduct on this kind of fine distinction between destruction, loss, wrongful conduct covered, and diminution. Not loss, wrongful conduct not covered.
Assume,
go ahead.
If miscarriage does cover wrongful conduct, so let's assume that, which is contrary to what you've been assuming, but assume miscarriage covers intentional wrongful conduct, then your arguments are?
So assuming, again, contrary mountain of evidence.
I'm reserving it. You're
okay.
not conceding anything. You're not conceding anything. Yeah.
Then I think our fallback position is that you have to think about, we basically argue Dolan, right? Dolan says loss is destroyed or potentially misplaced. Miscarriage is delivery to the wrong address. We are neither of those two. So we are some kind of transmission error. At common law, this would be called a willful refusal to transmit or a wrongful transmission. We give you case sites for that. Congress conspicuously doesn't include willful refusal to transmit in this list. It's only negligent transmission. So I think we still win, but I think if you decide for us that miscarriage only is limited to negligent conduct, you don't have to get into the kind of fine distinctions between the three terms. If I may make one other point about the kind of structure of the FTCA. So the FTCA's exemptions are divided into kind of two categories. Some are very broad, right? Any activities of the Tennessee Valley Authority, fiscal operations of the Treasury, that sort of thing. The others list specific actions, often with a mens rea, right? So 2680A, executing a statute with due care. 2680H, battery but not negligent touching. This one, 2680B, as Dolan said, is clearly in the latter mold, right? It's not saying any activities of USPS, any failings in the postal obligation, any mail handling activities. It's not doing that. It's listing three specific terms pegged to a mens rea, the way the other provisions do throughout the FTCA.
Can I ask you a question about Mr. Liu's point that miscarriage wasn't used as a verb at the time the statute was enacted. Justice Kagan said, well, you can lose the mail, you can negligently transmit the mail if you're the postal worker, or you can miscarry the mail, as in, misdirect it to the wrong place. And one of the responses that Mr. Liu had to that point was, well, miscarry wouldn't have been used as a verb. It was this term of art. What's your response to that? Because I do think it matters whether you view these words as something that happens to the recipient or something that was done by the postal worker.
Right. So I'll answer the miscarry question, and then I want to say one more word about that. So he's right that in general it was seen as intransitive, but the Webster's first and Webster's second dictionaries we point to note that it was sometimes used transitively. So you could say, in fact, Dolan says mail is miscarried if it goes to the wrong place. I'm not sure it matters a ton. You can kind of rephrase the question to get at the agent in a different. You could say, did the letter miscarried by Rojas? Was the mail lost by Rojas? And I think you're still in the same place. And I think whatever you think about miscarriage, it has to be clear that all the other nouns throughout the exceptions are not just did this happen, it's did the government employee do this, right? We give the example of assault. You don't come into court and say, there was an assault. You have to say the government employee assaulted someone. And so we think the same thing is true of loss. Again, if you don't buy that argument, I think the two other ways to think about the loss term, the first is sort of what we say in our brief, which is that typically loss is thought of as unintentional, and whether it's insurance contracts or cases or 1346B itself, people usually specified intentional loss or loss caused by wrongful conduct when they meant to change that default. And second, again, if you buy our miscarriage mens rea argument, there's just no good reason why Congress is saying one term encompasses wrongful conduct and the other two don't, particularly where, as Mr. Liu noted, there's some redundancy and certainly some overlap among the terms. If I can make one other point about consistent usage, and then I'll turn it over to Saharia in questioning. In 1346B, Congress is using loss in just a fundamentally different sense than it is in 2680B. We knew that because of the three textual clues that I gave you, and as a result, I don't think that the presumption of consistent usage even attaches, because it's only about where two terms are both being used to mean, for instance, deprive and deprive, the same source of deprivations count. It doesn't say that any time a term is used, it must be used in the same sense.
Thank you, counsel. Justice Thomas? Justice Alito?
Do you want to say something in response to Mr. Liu's point about the consequences of adopting your interpretation, which is that it's going to be very easy for people who are unhappy with the delivery of mail to claim that they're not getting their letters because of intentional conduct as opposed to negligent conduct? Is that going to be hard for people to plead consistent with Rule 11? I mean, a lot of people may think that what's happening is intentional. I don't get my mail because I didn't give the mail carrier a tip at Christmas, or I have a big dog that ran up to the door and scared the mail carrier on one point, or I complained to the mail carrier that he or she was putting my neighbor's mail in my mailbox, or putting my mail in the mailbox of my neighbors, or she or he looked askance at my holiday decorations, or there's some characteristic about me that the mail carrier doesn't like. Is that going to be hard? And what will the consequences be if all these suits are filed and they have to be litigated? Is the cost of a first-class letter going to be $3 now?
So I do think that's going to be hard. So remember, even alleging negligent conduct is tricky here, because if all you have is my package didn't show up, you're going to get kicked out of court. Certainly alleging wrongful conduct. And so, again, we're not just – I just want to clarify, because I think Mr. Liu's presentation maybe muddled these two things. We're not saying intentional just in the sense of, it didn't fall out of the bag. We're saying wrongful, as in you knew you were putting it in the wrong place. I do think that the Iqbal standard makes that quite tough, and that's particularly tough given the other FTCA guardrails, right? So still is to be within the scope of the employment. 2680A, right, basically says kind of mistakes of law or anything that gives the government employee discretion doesn't count. And if there's some conduct left that makes it into court, we know Congress did not want to immunize USPS wholesale or even all failings in the postal obligation. It knew how to do that. It did that with the majority of the other exceptions and didn't do so here.
All right, thank you.
Justice Sotomayor?
No, thank you.
Ms. Kagan? Justice Gorsuch?
Very quickly, I promise.
Yeah.
So there are various grades of mens rea.
Yes.
You knew it was coming, didn't you?
Uh-huh.
Yeah, all right. So you say this is negligence. Reckless? Knowing? Thoughts?
Right. So this is a general problem with the FTCA. 1346B carves the word into negligent and wrongful, right? This is written before Restatement Second, before the Model Penal Code. People didn't really think of recklessness as a different mens rea. What courts have said for purposes of 1346B, right? No one said, well, Congress said negligent and they said wrongful, so I guess reckless conduct is out. What they've said is, at the time, tort law equated recklessness with gross negligence, which is a species of negligence, and so recklessness kind of falls under the negligence bucket. I'll be candid, I haven't seen litigation over reckless conduct and whether or not it counts as miscarriage, but I'd assume it would operate the same way. That is, I think miscarriage covers good faith mistakes, even if they're like really bad mistakes.
Just to follow up quickly on Justice Alito's question, if you allege that you exchanged words with your mail carrier at one point, and so you're alleging that he intentionally misdelivered or did not deliver the mail, is that enough?
I certainly don't think if it's first of all, I don't think the one-off package gets into court because no one's going to pay a $400 filing fee and hire a lawyer if it's like one package that
Well,
gets
say
through.
it's a consistent slowness. You're alleging your mail's delivered slowly because you exchanged words with your mail carrier one time.
I think it depends on the extent. I think if it's 2 years and you can say every single one of my neighbors gets their mail faster than I do think you get past the pleading.
How about if it's just a week?
But I think the Iqbal standard is fuzzy. I would suspect a week is probably not long enough. And remember, this is not just allegations. Because this goes to jurisdiction, the way that all the other exceptions that turn on mens rea work is that the government can demand at a very early stage some sort of proof. It's not just you allege and you get into court. You can do jurisdictional.
Well, the proof will be I had a negative conversation with my mail carrier. You're not going to know, and that my mail was delivered more slowly or some important piece was not delivered at all. That's all you got, but that's all you can have. Is that enough? Get discovery?
I don't think 1 week would be long enough. But again, I think what Dolan said in response to precisely this argument, right? Frivolous claims are going to inundate the Postal Service. Dolan says the ordinary protections against frivolous litigation must suffice. And it turns out in the decades since, there hasn't been a problem with a flood of claims, contra the government's prediction.
Thank you.
Justice Barrett? No. Justice Jackson? Thank you, counsel. Rebuttal, Mr. Liu?
Thank you, Mr. Chief Justice. Just a few quick points. First, on miscarriage, we've pointed to dictionary definitions in pre-FTCA cases that show what the ordinary meaning of miscarriage was. The meaning was broad enough to encompass any time the mail failed to arrive. I think the burden is really on Respondent to point to something that justifies giving miscarriage a narrower reading than those historical sources show. She hasn't pointed to anything. I think the idea that miscarriage somehow incorporated some sort of model penal code-esque distinction between negligence all the way to willfulness is just wrong. Anytime the courts saw the mail not arriving, they labeled it a miscarriage, and that's how we think Congress used it in the FTCA. On loss, on consistent usage, I didn't hear any reasons to give loss a different meaning in the postal exception than in the sovereign immunity waiver. I think the main reasons my friend pointed to was that there is language in the waiver that doesn't appear in the postal exception, but that's built into the presumption of consistent usage. The presumption has work to do only when the word as it appears in Provision A is clarified by language in Provision A, but that language doesn't appear in Provision B. If that language did appear in Provision B, you wouldn't have to apply the presumption of consistent usage. This is a heartland application of that presumption. And the next point on loss has to do with this whole business of converting the words Congress used into verbs. The words work perfectly well as nouns. They describe the consequences that certain negligent or wrongful acts can have. For miscarriage, it captures the consequence of the mail not arriving, arriving late, arriving damaged, negligent transmission, the mail arriving late or damaged. There's just no one consistent way to take Congress's language and convert it into verbs. And it's for the reason Justice Barrett mentioned. You can't just convert all these nouns into did the government X the mail. It doesn't work with miscarry because miscarry wasn't used in that way. If you said that to a listener in 1946, they wouldn't know what you were talking about. Judge Cardozo's example in Heinrich is a good example. It talks about checks being lost in the mail, and it says the checks miscarried. And so there's no one way to redo Congress's language to make sense as nouns. I think what that tells us is just adhere to the language Congress used. It used nouns, treat it as nouns, and if you treat loss as a noun, there's no reason to give it a different meaning than the way Congress used it as a noun in the sovereign immunity waiver. Finally, just a couple points on my friend's approach to the exception as a whole. This whole separate ambit approach we think is misguided. The way I would think about Congress's thinking when it wrote the provision was it wanted to cover loss or injury to mail. Loss or injury is the wording of the waiver. And so when it got to the exception, loss is a perfectly good word to use when describing something that happens to mail. It thought we can describe injury using even more precise terms because there are words in our lexicon that describe bad things that happen to mail. So it picked up miscarriage and negligent transmission. Does this mean that miscarriage, they could have, after written the three terms, just gone back and erased loss and negligent transmission? I mean, maybe if they were really confident in how courts would interpret the language, but by including loss and miscarriage in addition to loss and negligent transmission in addition to miscarriage, Congress guarded against three arguments that they were worried might have narrowed the scope of the exception. One is the very argument Respondent is making in this case, that miscarriage should be limited to mail going to the wrong place. Another argument that they wanted to guard against, presumably, is the argument that the Fifth Circuit accepted, which is that miscarriage is limited to instances where there is some preceding carriage or some preceding attempt at carriage. And the third argument they wanted to guard against was the idea that by including miscarriage, the only types of injuries to mail that they were including were intentional ones. And so let's use negligent transmission as well. I think our position gives a coherent reading to the postal exception that avoids the deluge of suits that Congress was trying to avoid by putting the exception in the statute in the first place. And for all those reasons, we'd ask the court to reverse.
Thank you, counsel. The case is submitted.
and according to law, and that you will support the Constitution of the United States, so help you God. Be seated.
We will hear argument first this morning in Case 24-5438, Bowe versus United States. Mr. Adler.
Mr. Chief Justice, and may it please the Court. By its plain terms, 2244B1 applies to habeas corpus applications under Section 2254. It therefore does not apply to motions to vacate under Section 2255. After all, those motions have their own separate gatekeeping requirements. Resisting this straightforward conclusion, the court-appointed amicus proposes an elaborate theory that no court in the country has adopted. But the plain text, context, and structure of the statute make clear that B1 does not apply to federal prisoners. This court has jurisdiction to so hold. We have offered several arguments for why 2244B3E does not bar review here, but the simplest one is this. The subject of our cert petition was not the denial of an authorization. This argument is based on Castro and the passage on page 380 that starts with the sentence, even if for argument's sake. The court assumed that there was a denial of an authorization because the Court of Appeals had stated that the prisoner could not satisfy the gatekeeping requirements. But this court unanimously held that this denial was not the subject of the cert petition because the prisoner sought review only on the antecedent question of whether he had to satisfy the gatekeeping requirements at all. There is no material distinction between that question reviewed in Castro and the question here, which is whether petitioner must satisfy the gatekeeping requirement in B1 at all. Because there is jurisdiction, the court should seize this opportunity to resolve the 6-3 split that has evaded the court's review for the past several years and that will otherwise go unresolved. I welcome the court's questions.
Why would Congress want to treat federal and state prisoners different?
Justice Thomas, the short answer is federalism. We know throughout EDPA that Congress did in fact treat state and federal prisoners differently. We cited numerous examples in the statutory text that reflects that differential treatment. And we even see that with respect to second or successive applications as well, with respect to the newly discovered evidence criteria, which we know are different. The fact is that state prisoners, when they are in federal court and challenging a state judgment, the tension is high with the sovereignty of a state court. And so that is why we see it with exhaustion. We see it with the deferential standard in 2254D. We see it with the limitations on evidentiary hearings. And B1 is just another example of that differential treatment.
So what was the point, what was Congress trying to accomplish with 2255, with the addition of H in 2255?
In H, Congress was enumerating the two conditions that federal prisoners one of two conditions that they must satisfy before they can bring a second or successive 2255 motions. The only other thing it did in H was incorporate the certification provisions in 2244B3 that govern how that determination is going to be made.
As between federal and state, beyond the federalism issue, why would those be treated differently? The prisoners, the federal prisoners, and the state prisoners, they had been treated differently, but I think the effort by Congress was to bring them closer together in treatment.
Your Honor, we don't agree with that. We see numerous examples in EDPA where they are treated differently, so we know that they're not treated the same. And beyond federalism, we know finality concerns are different. State prisoners have had multiple rounds of review by the time they get to a successive 2254 petition, and the number of state prisoners far outnumber federal prisoners in our system. And so Congress would have been concerned about finality, most of all with state prisoners, including the fact that the vast majority of capital inmates here in this country are state prisoners.
Going back to that point, when you say multiple rounds, a state prisoner has had a state court, intermediate state court, final Supreme Court, a district court, and a court of appeals. But in federal court, a prisoner only has 2 rounds or 3 rounds of review, correct?
That's correct. What state prisoners have that federal prisoners do not is they also have state post-conviction review, which serves as an additional level of review that federal prisoners do not have. They also have, of course, the right to appeal any federal claim to this court, even on direct appeal of their state conviction. And we actually see a collateral estoppel bar in 2244C that applies only to state prisoners.
I'm sorry. No, please. Counsel, I don't want you to give up your first argument on jurisdiction. I know that in a previous statement I made in this very case, I suggested that it was wrong. But your brief gave me great pause. Don't give up on it. All right? Your position is that the cross-reference barring jurisdiction does not unambiguously incorporate that exists for state prisoners, correct?
That's correct.
And our case law is replete that to deprive us of jurisdiction, it has to be clear.
That's correct.
All right, and unambiguous.
Correct.
And this is not. All it says is that successive habeas motions filed by federal prisoners, quote, must be certified as provided in Section 2244 by a panel of the appropriate Court of Appeals, right?
Correct.
Now, that's not sufficiently clear because this court is not a panel of the Court of Appeals, right?
That is correct.
And so it's speaking about whether a full panel could hear it, not whether the Supreme Court could hear it, correct?
That's correct. To be clear, we are not giving up that argument.
All right.
We are simply saying, as we did on page 15 of our reply brief, that it's not necessary.
Because of the Castro argument.
And our other narrower arguments.
Right. But any review by this court of a panel cert decision is not part of how the panel certifies a successive filing, correct?
That's correct. Our argument is based on the text of 2255H, which incorporates the parts of 2244 that, quote, provide for how a motion is to be, quote, certified by a, quote, panel of the appropriate Court of Appeals. And our position is that incorporates B3A through D, because those provisions do just that, but it does not incorporate E, which comes into play only after the certification determination has been made, and it provides limitations on further review in the form of rehearing and certiorari.
And that doesn't your
sorry, no, please go ahead.
One last question. The two standards of review, H and what the state court looks for, you mentioned earlier, are very different things, correct? The substantive standards.
With respect to the newly discovered evidence, they are different. With respect to new rules of constitutional law, they are identical.
But there's still a difference.
With the newly discovered evidence, yes.
And 6 circuits are applying the state prisoner substantive review provisions rather than the federal substantive review provisions.
Our position is that they are applying B1, which on its face applies only to state prisoners. That's correct.
All right. Thank you, counsel.
Yeah.
Doesn't your reading of 2255H make a hash of the procedure that Congress has prescribed? An authorization to file a second or successive application must be certified by a panel of the Court of Appeals, and that court has to do that not later than 30 days after the filing of a motion. But on your reading, even though the panel has to move very quickly, once the panel has ruled, if it denies the application, then the prisoner can move for rehearing en banc, and there are no special time limits on that, or rehearing before the panel, there are no special time limits on that, can file a petition for a writ of certiorari, there are no special time limits on that. So doesn't your reading completely vitiate what Congress was getting at?
Sure. We understand that concern, Your Honor. Our position, this only goes to our broadest jurisdictional argument that Justice Sotomayor referenced, not our narrow ones. But to answer your concern, we don't think that Congress has to legislate in an all-or-nothing manner here. So with the 30-day limitation on the front end, that significantly increases the expediency of the process here. Where normally an appeal would take a year, now it takes 30 days. But that doesn't mean that Congress also wanted to eliminate all forms of further review. And we see Congress doing this in 2260 266, another provision of AEDPA, which places time limits on the resolution of capital cases, but does not dispense with further review and rehearing or certiorari. Of course, our position is that the court does not need to address this argument because we have three other narrower arguments, and this, of course, was the same approach that this court took in Castro, where
every court of appeals has decided the issue you've just been deciding against you, right?
In the context of rehearing, of course, no court of appeals has done so in the context of certiorari. But yes, I believe that is correct. However, none of the...
If that's correct, right, so just to step back, you agree that B3, A, B, C, and D are all incorporated in 2255?
Correct.
So we're left with E. And as Justice Alito pointed out, every single court that's addressed the issue says that that does bar panel rehearings and en banc rehearings. But you would ask us to overturn all those decisions, or do you think there's a way to say those decisions are correct, but it's only the bar that's pretty express, no certiorari, right there in E? Is it somehow different?
From the rehearing bar, no, that's not our position. We just think that the six...
so they're all wrong. All those courts are wrong.
Correct. They have not actually taken the text of 2255H seriously.
Okay, I appreciate that argument. I understand that argument. Is there something odd about the fact that you would bar cert petitions and rehearing petitions for not just state prisoners under 2254, but also any 2244 pre-conviction prisoners, but yet not federal prisoners? You see what I'm saying? I mean, 2244 isn't just post-conviction relief, it's pre-conviction relief too, often. That was its central and original function. And yet they couldn't bring cert petitions. They couldn't bring rehearing petitions. State prisoners can't bring rehearing petitions post-conviction, but federal prisoners can? Do you see the incongruity there that I'm observing?
I think it's a difficult question whether 2244B applies to 2241 habeas petitions, which I think is what your question is getting at. I certainly don't think the court has to decide any of that here.
But that is where your logic leads, and so I just wonder how that could be. What would be the rational account for it if that's how it works?
Our position is simply that the text here treats federal prisoners differently in B3E in the same way it does in B1, and that is, of course, due to federalism. That is a plausible explanation. Again, however, I don't think the court needs to go broad here when we have narrower...
But can you think of it, and maybe the answer is you can't on your feet, and I get it, any reason why pre-conviction prisoners would be barred? Post-conviction?
Well, Congress has drawn a distinction throughout the statute between people who are in custody pursuant to a judgment and people who are not. As for pretrial detainees, my experience is that they are not having to file second or successive motions to file their 2241 petitions. To the extent that's a category of cases, I'm just not aware of it. So I think in practice it just hasn't been an issue. But again, I just don't think that the court has to decide any of this in this case.
Right. So you keep going back to your narrow jurisdictional argument, and I'm quite interested in it. And I guess I'm trying to understand whether your response to Justice Gorsuch's bringing up all of the prior Court of Appeals cases is that perhaps they weren't focused on whether or not the panel had actually granted or denied, had actually applied the substantive criteria, and that what E is really doing, this is what I take your argument to be, is essentially establishing a finality requirement when the panel actually does apply the substantive criteria and makes a determination about whether this authorization should be granted or denied. But when, as here, the panel doesn't do that because it makes some other determination about, let's say, its lack of jurisdiction to make that kind of a ruling, that's still on the table as you read E. That's not being stripped by this statute. Is that right?
Generally, yes. We have three different narrow arguments here, and they're all slightly different, if I can just briefly sketch those out. The first one, logically, is that the Court of Appeals here did not deny the motion for authorization, the key word being denial, because the Court of Appeals dismissed it for lack of jurisdiction. It did not issue a ruling on the merits, and that argument follows from this Court's decision in Stewart. The second argument—
wait, that's sort of what I'm saying, right? It didn't make the requisite determination that triggers E. You have to grant or deny, not dismiss.
That is correct. That's our first argument. Our second argument is, even if there's a denial, the Court of Appeals did not issue a denial of an authorization because it went beyond the gatekeeping requirements. Now, this argument depends on whether we're right about B1, but if we are, it means that the Court of Appeals did not issue a proper authorization determination because it relied on a requirement that is, in fact, not a requirement for authorization at all. In fact, it's irrelevant to the case. And our third argument is based on Castro, and this is the one I opened with, which is that even if there is a denial of an authorization, it's not the subject of our cert petition. The subject of our cert petition is an antecedent question about whether we have to even satisfy the gatekeeping requirement in B1 at all. That is the line that Castro drew. And on the other side of the spectrum, if we had, say, challenged the Court of Appeals saying you cannot actually satisfy these gatekeeping requirements, that's a denial, that's barred. That is the sort of core focus of B3.
So under this narrow jurisdictional approach, there's still work for E to do. It's not as though your broadest argument is E doesn't even apply in federal cases.
Correct.
That's the one that Justice Sotomayor explored.
Correct.
But now you're saying even if E applies, it doesn't apply in our circumstance for these three
Correct.
reasons.
And this situation is so far removed from the core of B3E. B3E is about preventing this court from reviewing individualized applications and determinations, people seeking error correction in this court. This case is far removed from that because, first of all, we have a non-merits-based dismissal based on a gatekeeping requirement that we contend does not even apply in this case.
Thank you.
Well, you applied for authorization, right, to
Correct.
file a second or successive.
That's correct.
And is that still on the docket of the Court of Appeals?
No, it is not.
So it was denied, right?
No, Your Honor, there's a distinction between a dismissal and a denial in the statute.
It was effectively denied. What you're saying is it was denied on an improper ground.
Correct. The effect of it was a denial. However, we know from Stewart, this court's decision in Stewart, that the effect does not matter because the effect of the ruling by the Court of Appeals in Stewart was to grant authorization. In fact, the Court of Appeals transferred it to the district court. This court said it's not a grant of authorization, and the reason why is it didn't rule on the merits. Now here, the effect is to deny, but the effect doesn't matter. What matters is the Court of Appeals did not rule on the merits. That's our first dismissal denial argument based on Stewart.
Okay, thank you.
On your broader argument, picking up on Justice Gorsuch's question, the distinction between in-bank or petition for rehearing in the Court of Appeals and then this court's review might depend on the clear statement rule in part. How should we think about the clear statement rule and how to apply it here?
Your Honor, that is a correct distinction that the clear statement rule that this court applied in Castro to B3E would only apply to the certiorari bar rather than the rehearing bar. So if the court wanted to sort of decouple those, that would be the basis to do it. That's not our position. We just think that E is not covered by the text of the cross-reference in B3E because it comes into play after the certification determination has been made. And as the government acknowledges, B3E, it's just a limitation on further review. And so that's why we think the whole thing falls outside the scope of E. But you're correct that to the extent a clear statement rule would make a difference here, yes, the certiorari bar is even further removed.
What would a clear statement, what more would Congress have to do, do you think?
Well, we have a clear statement in E itself with respect to state prisoners, with respect to habeas applications. What we don't have is a clear statement in H, where we're talking about federal prisoners. And we pointed this out in our initial brief with the Hone decision. And that case drew a contrast between B3E as a clear statement and the certificate of appealability provision in 2253, which didn't have that. And we think that same sort of contrast exists here with B3E and 2255H, which says nothing about jurisdiction.
2255H does say, and this is just as I'm trying to think about this argument, this clear statement point that you have, I think, is your best one on your broader argument. 2255H does say, though, that a second or successive motion must be certified as provided in Section 2244 by a panel of the appropriate Court of Appeals. So what are we to make of that? It says certification has to come from a panel, and then one could flip back to 2244 and say that this whole section in 3 is talking about how that certification happens by a panel, and then E says, and yeah, it really happens by a panel. The panel's word is final.
Your Honor, I understand that point. That's not what E says, however. All E does is prohibit a petition for rehearing, so that's why every circuit to look at this has said that sua sponte rehearing is still on the table. All we're saying is that B3A through D say that the certification determination has to be made by a 3-judge panel, but it doesn't prohibit rehearing petitions by federal prisoners. So it's a difficult argument and a difficult issue, again, that I don't think the court would have to address if it went with one of our narrower arguments.
I mean, what E tells you is when this certification process generally stops. I suppose that's the same point that Justice Barrett is making, and it seems to be slicing the bologna pretty thin to say, well, we'll do A through D, but then we won't do E, even though E basically puts the period on what A through D says. It says, here's when it ends, the certification process.
Sure, Your Honor, we take that point. I think the key word that you just used is process, which is not a word that's used in H. That's a word that's added by the government in its brief, along with the words final and conclusive.
I take the point, but you know, it's what H is about is how something gets certified. So it doesn't seem to be too much of a leap to say when you're talking about how something gets certified, you're talking about the certification process, and that includes sort of the statement which E gives about when and how that certification process ends.
Sure, Your Honor. So again, our argument is based on the full text of H, certified as provided by a panel of the appropriate Court of Appeals. We think that only covers the provisions that provide for certification. E comes after that determination has been made.
Could you win without the clear statement rule?
I'm sorry?
Could you win this argument without the clear statement rule?
I think so, Your Honor. But again, I think we're perhaps losing sight of the bigger picture here, which is that the top priority in this case, we think, is for this court to be able to resolve the circuit conflict on B1. So we don't have a particular dog in the fight on how the court resolves its own jurisdiction here. And that's why I keep coming back to our narrower arguments, because to the extent that anyone is concerned about the implications for this, the narrower arguments would avoid that.
Thank you, counsel. In your brief, you argue that interpreting B3E as taking jurisdiction away would raise serious questions under the exceptions clause. You want to answer that serious question?
I certainly don't want to answer that question, Your Honor, but I think this court might have to if it rejects all of our jurisdictional arguments, such that there is really no way for this court to exercise its essential function under Article 3, which is to ensure the uniformity of federal law, including a very important federal statutory provision in AEDPA.
Well, it says that, not with respect to AEDPA, but subject to such exceptions and regulations as Congress may make. Why isn't this just an exception that Congress has made?
Sure. So if you reject all of our jurisdictional arguments, and given the potential unavailability of original habeas petitions by federal prisoners after Jones v. Hendricks, there is really no viable way for this court to be able to ensure the uniformity of federal law here. Now, the amicus brief by the federal courts professors lays this out very well and summarizes the scholarship, but this case is a unique one in the sense that original habeas has always functioned as a safety valve here. That's what the court has always pointed to. And if that's not available, and if certiorari is not available under any of our arguments, then that is why I think we come into serious problems here with the exceptions clause. And I think the court can simply avoid all of that if it narrowly construes B3E as it has always done in the only two cases where it's interpreted that provision in Stewart and Castro and exercises jurisdiction on one of our narrower arguments, and therefore directly resolve the conflict over B1.
But we've never held that the exceptions clause does not mean what it says, have we?
I'm not aware of any decision by this court resolving that question, no, and I don't think that this is the case to do it because of the avoidance, the avenues we've given this court to exercise jurisdiction on some other narrower ground.
Thank you, Counselor. Justice Thomas? Justice Alito?
On the relitigation bar, what's your response to the argument that Congress may not have been particularly attentive to terminology, but that the thrust of what it was trying to do was to apply the same rules to federal and state prisoners?
I think there's simply no evidence to support that in the text. We have 2254 appearing in B1 and B2, but not in B3, by the way, which everyone agrees the certifications there do apply. So that distinction is important. Everybody agrees. The 11th Circuit, court-appointed amicus agree that B2 doesn't apply to federal prisoners, and it uses the exact same 2254 language. And then we have two separate and independent gatekeeping requirements for federal prisoners in H1 and H2, state prisoners in B1 and B2. So it's a symmetrical regime that they set up here. So I think every textual indication here is to the contrary.
All right, thank you.
Counsel, if Congress wanted to include the cert bar, it could have just said, as provided in Section 2244B3, correct?
Correct.
But it didn't. It used a different phraseology.
Correct. Correct.
And the process that was used, that it references, is a process of court certification, not of cert, correct?
Correct.
And that's your basic point.
That is supportive of our basic point. Our basic point is really a textual argument here. It's not a policy argument. I think that's what the government is trying to say here is we don't want to see a lot of cert petitions here because we're overworked. I think that's the main concern. But we're making a textual argument about the scope of the reference and cross-reference in H.
Go back a moment to the Chief Justice's question, okay? With respect to review by the Court of Appeals, or why isn't there a constitutional question with EDPA, but there would be one if we deprive federal prisoners of review of this issue?
I think this particular circuit conflict on B1 is unique in the sense that it can be raised only by federal prisoners. And if federal prisoners can no longer file original habeas petitions in this court challenging their conviction and sentence after Jones v. Hendricks, then this particular split, I think, highlights the potential constitutional problem in a way that no other split would. Now, other splits could still raise the question because this court is rarely, if ever, actually used its original habeas power, but this particular split I think is the problem here because there's really no other viable way for this court to resolve this circuit conflict on B1.
And the circuit conflict is on whether the successive petition bars review at all.
No, the circuit conflict is on whether B1 applies to 2255
B1,
motions.
that's what I meant.
Correct.
Okay, thank you.
Justice Kagan?
Mr. Adler, the clear statement rule that you invoke from Castro, I take it comes from the sentence where it speaks of the basic principle that we read limitations on our jurisdiction to review narrowly.
No, Your Honor, there's a sentence, I believe, right before or right after that, it says that we are not going to read B3E in a manner that would close this court's courthouse doors to a class of habeas petitioners without a clear indication that Congress sought to do so.
Clear indication.
Correct.
Okay, thank you.
Justice Gorsuch?
We haven't given you much of a chance on the merits to speak, and I do have one question for you about that I'm struggling with. So you agree that B3 and B4 apply when we get to the merits, right?
If you reject our broader jurisdictional argument, then we would agree with that.
Okay.
But not if you agree with it.
I understand that.
Okay.
So we got B3 and we got B4 in there, but not B1 and B2.
Correct.
And one of the main arguments, as I understand it, has been because B1 and B2 speak about applications under Section 2254, right?
Yes.
Okay. I wonder why that doesn't cut the other way, because throughout 2244, B1, 2, 3, 4, it speaks of applications, not motions, which you have in the 2255 context. So you gotta read motions as applications. Okay. And 2254 is the state post-conviction procedure that's most analogous to 2255, right?
I would agree with that, yes.
Okay. And that's what's referenced in B1 and B2 is the state post-conviction procedure. Mm-hmm. And B3 and B4 just talk about applications, which includes pre-conviction, again, 2241 possibly. So what do we do with that? It seems to me like the fact that it mentions 2254 in B1 and B2 makes it more likely to be applicable rather than less.
No, Your Honor, we strongly disagree.
I know you do, and I'm wondering why.
Here's why. Because the fact that 2254 is referenced in B1 and B2, but not B3 and B4, suggests that, number one, the 2254 language in B1 and B2 was deliberate, and number two, it suggests that the omission of that language in B3 and B4 allows those provisions to apply to 2255 motions in a way that B1 and B2 cannot.
But why wouldn't I understand that. That's what you said in your briefs. But I'm not sure it's totally responsive to what I'm getting at, which is it definitely signals that we're talking about post-conviction when you mention 2254. Mm-hmm. And the later sections suggest it applies to all habeas, whether it's 2241 or 2255, right?
No. So B3 and B4, which don't have the 2254 language, we acknowledge what you said earlier. I think everyone agrees the word application, which refers to a habeas corpus application, has to mean motion in order for the cross-reference in H to work.
Right, I understand that.
So then the question is, once you adjust application to motion, then what do you do there? All we're doing is we're reading the rest of that B3 in that context. What amicus wants you to do is, instead of adjusting, requirements of this subsection, she wants you to keep that the same as it applies to applications, and then go up to B1 and B2 and rewrite 2254 to mean 2255 in a way that would immediately create both conflict and superfluity with H1 and H2.
Okay. Thank you.
Counsel, I want to sketch something out for you and see if you think it might work. Okay, so the government points out on pages 12 and 13 of its reply that if we agree with you about your B1 point, agree with you and the government about the B1 point, that it would be pretty natural, even if we disagree with you and agree with the government on the jurisdictional point, pretty natural to express agreement with the B1 point in the course of an analysis on the other. Okay, now let's say that and this is true, I do think there's something to this argument that the courts of appeals have made that E does not deprive them of jurisdiction to sua sponte have a panel hearing, rehearing en banc, panel rehearing or rehearing en banc, because it's really talking about the prisoner's inability to file such a petition or a petition for writ of certiorari. Okay, so this is what I'm sketching out here. Wouldn't it be possible if this court said in the course of the analysis, as the government proposes, that B1 is not incorporated, wouldn't it be possible for the 11th Circuit on remand to sua sponte correct its error? Wouldn't it be quite surprising, in fact, if the 11th Circuit didn't do that, sua sponte, if it has the authority under E, either by the panel or en banc, if we say that it is wrong in B1?
The problem with that, Your Honor, is that there will be no remand if the court dismisses this case for lack of jurisdiction. So we don't think the court should consider the government's proposal on page 12 unless the court totally rejects all of our jurisdictional arguments. That's the only—
That was the premise of my question.
Oh, okay, I'm sorry. So yes, then there would be no remand for the 11th Circuit to do that sua sponte rehearing that you suggest. And this is our concern here with this suggestion, is that it's even beyond that, which is that if the court tries to resolve the B1 conflict in the course of dismissing this case for lack of jurisdiction, we are concerned that the courts of appeals may perceive that to be dicta or worse, an advisory opinion. So if the court does consider that option, we would urge the court to be as explicit as possible on the B1 question, even to the point of saying that the reasoning on the B1 issue is a holding. Otherwise, what's going to happen is that if even one of the 6 circuits says, you know what, this is dicta, it doesn't abrogate our prior panel rules, and the 11th Circuit in particular has a very strict one, then we're in a situation where there's no way to get back up to this court on cert, and the circuit conflict will never be resolved. And then we'll have wasted all of our time, and this will all be for nothing. So I think the better way to deal with this, rather than that sort of very unorthodox approach, is to narrowly construe B3E as it has always done, as this court has always done, and directly resolve the circuit conflict over B1.
Okay, well, I don't know that that would be unorthodox because we say things, we have alternate holdings and we say things in opinions all the time that aren't directly relevant, but I take your point. Just one other question. The Chief Justice asked you about the constitutional avoidance on the essential functions piece, and you say that, yes, it would raise a constitutional question because construing this jurisdictional bar to be total would threaten the court's essential function of maintaining the uniformity of federal law. Why wouldn't that completely eviscerate the exceptions clause? Because it's possible to have a split on any question of federal law, right? So why could Congress ever withdraw our jurisdiction to weigh in on any question? Because even if a split doesn't exist then, it could always exist, right?
We're not saying that it wouldn't. A problem wouldn't arise in that situation. I think it's important to point out that this statute, B3E, is unique. There is no other statute like this. There are plenty of statutes that bar judicial review across the board, but there is no statute like this that targets this court's certiorari jurisdiction. And the problem that arises is the lower courts, the federal courts of appeals, are interpreting and applying AEDPA. And if this court cannot superintend that and step in when there's a conflict,
so Congress can't, I mean, I take then the straightforward answer to my question is that, yes, Congress can really never deprive this court of certiorari to resolve questions of federal law because that would deprive us of our ability to ensure the uniformity of federal law.
I think there's at least a serious question about that, and that's because whenever lower courts are deciding issues of federal law and this court cannot step in, then this court ceases to be the Supreme Court. The courts of appeals then become their own mini Supreme Courts. Thank you.
Justice Jackson? Thank you, counsel. Mr. Yang?
Mr. Chief Justice, and may it please the Court. Section 2255H incorporates the certification process for second or successive applications in 2244 B3 and B4. And because B3E prohibits review by petition for writ of certiorari, this court lacks jurisdiction. 2255H specifies three key aspects for certifying a successive application: who must certify it, what is certified, and how that process proceeds and stops. First, certification must be by a panel of the appropriate court of appeals. Second, the application must be certified to contain either of H1 or H2's content requirements for new evidence or a new rule of constitutional law. And third, the application must be certified as provided in Section 2244, which means the certification process proceeds in the same manner as in 2244. B3 and B4 are the only provisions in Section 2244 that address the certification process for authorizing the filing of a successive application. Every provision in B3 and B4, and only those provisions in Section 2244, use authorization language and use the term second or successive application, a term that naturally captures a federal prisoner's 2255 application and a state prisoner's 2254 application. Petitioner agrees that B3A through D apply to federal prisoners. He previously argued in his habeas petition to this court that E also applies, and there's no sound basis for excluding E, as every court of appeals to have addressed the E has concluded. Petitioner did not even attempt in his reply brief to rebut any of our arguments on this broader point. He instead notes that E prohibits cert only when authorization is granted or denied. And he primarily focuses on that point, saying his request was not denied, it was merely dismissed. But a dismissal is quite literally a denial of his request. That denial is the subject of his certiorari petition. This court therefore lacks jurisdiction. I welcome the court's questions.
Mr. Yang, would you turn to the clear statement rule and how it applies here?
Yes. We think the language is clear, both the text as well as an important contextual point, and I'd like to build on what Justice Alito said there, and then I'd also like to address the clear statement rule, which I don't think is as clear as Castro, the one passage in Castro might suggest. First, the contextual point, and we can talk about text, but one significant contextual point is not only would allowing a 90 to 150-day period simply to petition this court for writ of certiorari, not only would that blow the 30-day limit apart, But you have to ask, why would Congress impose a 30-day limit on the most important part of this process? That's the Court of Appeals screening decision itself. Why would that be limited to 30 days if Congress contemplated that a petitioner could take 90 to 150 days just to consider whether to file a petition for writ of certiorari?
Mr. Young, that might be a good argument, but it's not the kind of argument that you can make if there's a clear statement rule.
Oh, and I think, though, actually context is considered. If you're looking at statutory construction for clear statement, you would include both the text and the context. And we think that
you might put it in as like, and also.
Well,
but you need something in the text that is a clear indication, that is a clear statement, that basically says what you want to say.
And we think H does that. H incorporates that shall be certified as provided in 2244. And part of that process is to decide who is certifying it and how is it being certified. It's being certified on a request for leave to file filed by a petitioner, a prisoner. It's not on a petition for rehearing or on a petition for cert. The process ends. It does not continue.
When I tried a version of that argument to Mr. Adler told me that I was adding the word process, which no place appears in the statute. And,
well,
of course, he's right about that.
Process doesn't appear, but it says certified as provided in Section 22.
As provided by the Court of Appeals. So that would suggest that even though it looks a little bit weird to go from A to D and skip E, what 2255H describes is the stuff that's described in A through D, but not in E.
But that's just part of the analysis. You also have to look at the language in E. E uses second or successive application, and it talks about the authorization. Second or successive application, if Congress had intended to include, to cut out state prisoners, it would have done exactly what it did in B1 and B2. It would have said, second or successive habeas corpus application under Section 2254. Instead, B3 and B4, which are all procedural provisions regarding the process, which we think is incorporated, all use distinct language. And no one has come up with any explanation that will respond to the Rosello presumption. It's a strong presumption. All of these provisions were enacted at the same time.
Could you comment on Mr. Adler points to this language from Castro, which is about this very provision, of course. And it says that, read one way, it would close our doors to a class of habeas petitioners seeking review without any clear indication that such was Congress's intent, indicating that a clear indication is what's needed, given the basic principle that we read limitations on our jurisdiction to narrow.
I think that should be read somewhat narrower. It has to be read in light of what immediately preceded it in that paragraph. In that paragraph, the court says, first, we've already construed E to allow the government, when the lower court disfavors the government can seek review on the question of whether it was a second or successive. And then it goes on to say, and we're not going to deny the flip side rule when a prisoner comes up. But that is all in the context of asking the core question of, was this a second or successive application? Was it in the box that the jurisdictional bar comes from? And that's all.
Do you think there's a clear statement rule or not?
I think no.
No?
At least not as broadly defined. If you look at
what does that mean? I'm not.
Well, if you look at what Castro cites, it cites for the clear statement, Utah versus Evans.
You think there should be a clear statement rule? Add that in, too.
No. First of all, this court has narrowly construed grants of appellate jurisdiction to it. Mandatory appellate jurisdiction under 1253 and what was formerly 1254-2. And if you look at like Abbott versus Perez or Maine versus Taylor, the court narrowly construes those grants of jurisdiction, and it does not sit comfortably to narrowly construe exceptions to jurisdiction in light of those precedents. And if you look at what the court was doing—
Meaning Congress has given us a very broad jurisdictional grant over decisions by Court of Appeals through our cert jurisdiction. And when Congress wants to take it back, it's when we require clarity.
But that reasoning would equally apply to 1253, which is the three-judge district court appeal, or what used to be 1254-2, which is state appeals with regards to the unconstitutionality of state provisions. Both of those are phrased broadly, but the court has narrowly construed them in a long line of decisions. Now, the the question about what was going on in Castro, I think, has to be read in light of that. And
Are
in
you
light
going
of what,
back to Justice Kavanaugh's question?
Yeah, I'm trying to pivot back to what Utah versus
the reason for a clear statement rule or clear indication is that the underlying constitutional question is one that we haven't had to squarely answer for 236 years.
Yeah, and the exceptions clause, if you were going to address the exceptions clause and the scope of Congress's power there, it would not be in the context of a habeas appeal. Because at the founding, it's well established that there was no right to appeal at all the denial of habeas. It was not in this court's or any court's appellate jurisdiction. And so the idea that there would be an exceptions clause problem is just completely ahistorical.
So we get out of that, in your view, because this is just different because it's habeas?
It's habeas. I mean, and there's just no founding era principle that would have applied here. Moreover, there are some bases for review. I don't think that.
Yeah, what are those?
Yeah. So, first of all, I think as Justice Barrett indicated, this court could, if the court took the interpretive approach that we did here, I think its decision on jurisdiction would effectively announce the proper interpretation.
Would the lower courts have to follow that? I think not.
You know, I would think it would be a pretty willful.
Well, what would we do if they didn't?
Well, if you didn't, there is the question of sua sponte en banc, which we can discuss. But if you wanted to address it specifically, I think there's a question of a certified question to this court.
And if it's not certified?
Well, first of all, I think the Court of Appeals misunderstood the certification standard. The certification standard here is whether it's appropriate in a rare instance when advisable in the proper administration and expedition.
The only point I was making is that it seems pretty cute to kind of have a collateral dicta and expect everyone to follow that when we're openly saying, under your view, no jurisdiction.
It depends on how the court writes the opinion. I think it's not the court will not go out of its way to escape the rule on the merits when addressing jurisdiction. But if you agree with us, the natural way to do that is to analyze the statute in a way that will carve out B1.
Mr. Adler,
what about relief?
At the very least.
Oh, I was just going to ask, what about relief for Mr. Bowe on remand?
Well, Mr. Bowe might not, there wouldn't be a remand, but Mr. Bowe has already filed multiple applications in the 11th Circuit on his.
But your solution.
Just file another one.
But your solution for the page 12 and 13 of your reply proposal that you make would apply for other petitioners in other circuits, but would not help this petitioner.
On this application, but he could simply file another successive application.
And why wouldn't it suffer the same fate? They've already said they're now certifying to us. They've already said they're not.
No, because the Court of Appeals would say the reason we bumped it before is we thought B1 applied. The Supreme Court has construed 2244.
So a third or fourth successive petition for him would be a second or
he's
third
not,
or
he's not even filed a second application.
Thank you.
So, Mr. Yang, can I just, let's say I agree with you that E is a part of the certification process that is being referenced in H. Can I have you address the more narrow jurisdictional argument, which does focus on the text of E? Your argument seems to suggest that we should not pay attention to the difference between granting and denying something, or denying an authorization and dismissing the entire matter for lack of jurisdiction. And I guess I don't understand that. We have very clear procedural requirements and understandings when a court is doing certain things. And here, the Court of Appeals panel did not grant or deny an authorization.
Well, we disagree with that.
Okay.
The statute says, and this is D, the court shall grant or deny authorization. Shall.
Right.
Those are the only two statutory
What if
options.
the court doesn't do that? Let's say the court, let me give you a hypothetical. All right. Suppose we have a 3-judge panel that doesn't do what Congress has said you're supposed to do with respect.
What does it do?
No, let me finish.
Yeah.
All right. So in my hypothetical, the 3-judge panel doesn't apply any of the relevant statutory criteria when it reviews an authorization request. So you agree here that the H1 and H2 substantive requirements apply. And in my hypothetical, the panel says, we don't care about that. We're just going to rubber stamp all of these applications as deny. All right? So we have a rogue panel not following what the statute says. Now, they've technically denied in that sense, but they certainly haven't followed what the statute says. They haven't granted or denied on the merits. And I guess I'm trying to understand why E would preclude someone from appealing that. It seems to me that E was really just about Congress not wanting the actual substantive determination that a panel properly makes to be appealed. What it was not doing was policing all of the, or precluding an appeal about whether or not the panel had acted procedurally properly under the statute.
Well, there's two responses. One is a textual response, and then I think you're actually getting into a policy response.
No, I'm not, actually.
Well, the textual response is this. It says grant or deny. Literally, a dismissal is a denial of the application, as this court has recognized in Gonzalez. It's denied on the ground that the claim would be dismissed. Now, whether a court is wrong in a denial or wrong in a grant, it can happen both ways.
No,
the
but
grant
we're
or
talking,
denial is not subject to review by this court.
I guess I understand your point. It just seems to me to elide a very key and critical thing that Congress was trying to do here, which is Congress gave this panel particular requirements that it has to apply when making this decision. One could conceive of the finality requirement as being once the panel has gone through and applied H1 and applied H2 and determined that authorization should be denied, that's the end of it. That's final. That's the work of E. To me, and I think textually, it supports the view that if a panel has not done that, if a panel has not actually made a determination about whether or not this should be granted or denied, and say they have dismissed it for some other reason, it doesn't trigger what E is trying to do. There isn't a finality requirement in the same way. Why would Congress have even put in the substantive criteria if the panel could do whatever it wanted? There still has to be judicial review as to whether or not the panel has acted properly procedurally pursuant to the statute.
That premise does not lead to the conclusion. Of course, Congress wanted the panel to follow the law, but the question is whether Congress determined that there should be certiorari review of claims that the panel erred. The statute doesn't
respect
say
to what?
But the statute does not say grant or deny on the merits. It says grant or deny, period.
All right.
And a dismissal is a denial. Moreover, the structure you have with a 30-day time limit. That time limit cannot depend on the disposition of a court, which is unknown in advance. If the court doesn't know if it's going to dismiss or deny, it can't operate under a 30-day time limit unless it knows what the time limit is in advance. That theory of dismissal being distinguishable from denial would apply not only to E, it would apply to D, which is where the 30-day time limit is. It makes absolutely no sense. It's arbitrary, and it would also be asymmetric. It would allow where denials on a non-merits ground, that could go up on cert, but if granted, like if the court rejects a non-merits ground and allows it to go forward, that couldn't be. Again, that doesn't make great sense, and it's not compelled by the text. I think we were talking about certified questions briefly. I just want to address this because I think this is important. The Court of Appeals said that certified questions are very rare, and that's right, normally. But that's because certiorari jurisdiction is available. The standard is when it's advisable in the proper administration and expedition of judicial business. When there's cert, which can be granted before or after judgment, extraordinarily rare. But if cert's not available, and there's a square and significant conflict that's recurring, it's entirely appropriate for a Court of Appeals panel, and you only need 2 judges on a panel, to certify the question to this court, and then this court could decide what to do. Moreover, there's merits review. As you may remember, Justice Kavanaugh, you wrote separately in a case called Avery. Avery came out of the Sixth Circuit raising this exact B1 issue, but it came in a different posture. It came where the panel, a panel certified a second or successive. It went down to district court, was litigated, and came back. The issue can come back on the merits in that way, too. And, of course, there's All Writs Act jurisdiction. All Writs is not precluded. Now, it would only address clearest errors, but it still exists.
The standard there would be indisputably clear.
It's a very high standard, but it would take care of the clearest errors. Now, there's a question, and so even if which I don't think it's clear, but even if there weren't original habeas in this court, which is what I think the hook that Petitioner relies on, there's other avenues for this court to address these issues.
Mr. Yang, when you and Justice Kavanaugh were talking about the clear statement rule, your answer to him seemed to reduce to habeas is different. But of course, Castro is a habeas case, and Castro dealt with the very habeas provision that we're talking about here. And I guess you referred me to earlier sentences from Castro, and I've read those sentences again now. Mm-hmm. And I really don't see how it gets around what Castro says, which is that you need a clear indication to when the interpretation would limit our jurisdiction.
I think it has to. This is a two-step process. First, the court recognized we already allowed this for the government. Now we're talking about the flip side. Same question, though, about whether it's second or successive, whether that's barred. And then you look at Utah versus Evans, which is ultimately the site for the narrow reading.
Yeah, but
provision.
Utah, I mean, that's the kind of site that people throw in because it has good language. So I don't think you can read Utah v. Evans back into this.
Well, there's two things actually going on in Utah versus Evans. First, which I don't think applies, but it says that with respect to this narrow reading, it rejects the argument that because Congress allowed a pre-census challenge, it precludes a post-census challenge. But that's about any review. It's not this court's review.
This is not an opinion, is what I'm trying to say, where it says, really we should look to Utah v. Evans for the rule, and describes why or describes how this case is the same as Utah v. Evans. It's just plucking some language from Utah v. Evans. But the purport of this paragraph is quite clear, is that because there's a construction that limits our jurisdiction, you need a clear indication.
But the part of Utah versus Evans, which is actually analogous to what's going on here, is there the court said that it was not going to read into a statute an unexpressed intent to bar jurisdiction that we have previously exercised. And there the court had previously exercised post-census review. And here what the court is saying is we've previously exercised jurisdiction when the government comes up saying this is second or successive when it was deemed not to be. And here's the flip side. Here is the prisoner. Now maybe on that
I don't read any of that in this paragraph.
Well, this is how we read the paragraph, because there's 3 sentences in the paragraph.
The paragraph doesn't say any of that.
Well, it's true that the paragraph doesn't say that explicitly, but I think you have to read between the lines. Anyway, the principle that this court's cert jurisdiction is always
I would be reading between the lines so that we could do your policy arguments.
Well, no, I don't think it's a policy argument. We have textual arguments, but I don't think this is also actually a relatively significant question that intersects with Congress's authority to exercise its exceptions clause. And I think there, the question is, why do you need a clear statement? This has not been followed by this court. This is kind of an isolated thing. And if you look at the authority for it, it just doesn't bear fruit, particularly when you look at how the court has construed its mandatory jurisdiction.
Well, Mr. Yang, there's been a lot of talk about a clear statement rule, which seemed to suggest that some sort of verbal formulation is required, but what Castro says is that there has to be a clear indication of Congress's intent. So what Castro says is that we look to the intent and some clear indication of intent. Can't that indication of intent come from something other than specific words? Can it come from the structure?
Certainly. I mean, that's normal statutory construction. You determine the meaning of Congress through interpretation of the words and the context and surrounding provisions. And again, all of these are coming together, in our view, to point in our direction.
And do you think those structural arguments are policy arguments?
No, not at all. These are textual arguments. And, no one has come up with an answer. No one has come up with an answer to why Congress used particular text, second or successive application. In E, A, B, C, D, and E all use that broad language that naturally captures 2255 and 2254. Why did it do that? And then in B1 and B2 uses the very specific targeted language. Habeas corpus petition under Section 2254. That is, I think, almost fatal to any argument that either the amicus or petitioner has that would sweep out, either jurisdiction or sweep in B1. Now, I would say the amicus, if you take the amicus's reading, the amicus's reading would sweep in E anyway. We'd win on jurisdiction under the amicus's reading. But there's just not been a textual explanation for Congress's deliberate use of this distinct language. That language, though, maps directly. The language is both the authorization language in B3, A through E, as well as 4, the authorization language and the broader use of second or successive application. All of that directly maps onto a 2255, which is asking about the certification process in 2244. So when you add all of that together, we think there's a pretty strong and compelling textual reason to conclude that there's no jurisdiction here. And the idea that this is a dismissal, not a denial, I think is countertextual. And not only that, I think we really haven't gone into what Castro says, but Castro's holding is ultimately that the subject says the subject is not the denial of authorization, which would be the denial of authorization to file a second or successive. It is the lower court's refusal to recognize that the 2255 motion is his first, not his second. That, again, maps directly onto the question of whether it's a second or successive under the jurisdictional provision that bars review of denials of second or successive. All that Castro, just like Villamonte Marquez or Stewart, if you call it that, all those two cases were deciding was that these cases aren't in the box of second or successive. The whole grant or denial thing is not relevant here. Therefore, there's no jurisdictional bar. If you were to start construing the cert bar to include, well, we're going to look to the reason, maybe this applies and maybe that doesn't apply, you're creating a huge hole when Congress used broad language to say it's going to be any grant or denial of authorization.
Does it matter, Mr. Yang, that in Castro there was a dismissal of the motion for failure to comply with the second or successive?
It does, because what happened
Just like there's a dismissal here for failure to, or for lack of jurisdiction?
It's different. The procedural posture is very different. If I may finish. Yep. The procedural posture in Castro was that the prisoner filed a 2255 application, actual application, the habeas court, if you want to call it habeas, 2255 in district court. The district court dismissed it because it concluded it was second or successive without certification from the Court of Appeals. That went up on direct appeal to the Court of Appeals on a COA. The Court of Appeals said, yeah, we agree. This was second or successive, therefore it was not properly filed in district court to begin with. Then it comes to this court on cert. There's no limit. This is kind of like an Avery issue. It came up on the merits because it had been resolved by the Court of Appeals. And the Court of Appeals said, this court said, no, this is not the grant or denial of the second and successive. It's just a normal case.
Thank you, counsel. Mr. Yang, would your arguments be different, and why, if Congress decided this is still getting to messy whatever, and the decision of the district court judge will be final?
I'm sorry, I didn't.
The decision of the district court judge in these matters will be final and not subject to further review. Same language with respect to the Court of Appeals decision, except applying it to the district court.
I think it'd probably be the same. I mean,
So the department's position is that you could cut off review after a district court decision?
Well, I'm a little confused. Is the district court decision like a screening decision? Is that what you're...
Well, just in the final regular application of whatever, the habeas application.
There might be distinctions between a final disposition. I think with respect to the exceptions clause, I think we'd have to revisit the question about what was expected at the founding when Congress enacted Article 3, and Congress would
not the exceptions clause, just whatever kind of provision that no further review. You're basically cutting off the review at the Court of Appeals stage, and I just wonder, why don't your arguments support the idea of cutting review off at the district court stage?
If Congress enacted a statute that said the district court's determination in some set of cases shall be final and not subject to review of any form, that would be a little harder. I mean, you might not, therefore, you wouldn't get certification. There wouldn't be other avenues. I think it would be a little more difficult for purposes of the question about an exception to this court's appellate jurisdiction. But again, if this was limited to the habeas context, again, it's not clear to me that as an original matter, when you go back to the founding, Article 3 would have thought that that's an issue, since there was no appellate jurisdiction at all over habeas determinations.
Thank you. Justice Thomas?
Justice Alito? On the issue of constitutional avoidance, haven't we said that there has to be a real potential constitutional problem that hasn't been considered, and that the canon, the constitutional avoidance canon, doesn't mean, well, if there, if somebody suggests that there might be a constitutional problem, then the canon comes into play? Haven't we limited that canon in that way? And has this exceptions clause issue been briefed adequately in this case for us to base a decision on avoiding a potential exceptions clause issue?
Well, there's two questions there. I think you're right that you need a very significant constitutional question in order to avoid it. And then two, whether the briefing is sufficient, I would leave that to the court. We address the exceptions clause in two ways, both as an original matter discussing the habeas jurisdiction, as well as the fact that there are other avenues for this court's review outside of cert from a denial of or grant of leave to file a second or successive. Whether that's sufficient, I would leave that to the court.
Is the limitation that you think is placed on our jurisdiction here at all comparable to a rule that would prevent us from reviewing the merits of cases decided by a district court or a court of appeals?
No, this is much more narrow. Remember, the posture that this comes up in is there's already been direct review through the federal system. There's already been one full round of collateral review through the federal system, including a cert petition to this court. Now we're talking about seconds or successives. The aperture of the case has really narrowed down, and Congress had very significant finality concerns in this context, both with respect to federal prisoners as well as state prisoners, and therefore appropriately provided for certification that's just done by a panel of the Court of Appeals in 30 days and not subject to cert with the 90 to 150-day deadline to file after. The process ends in the Court of Appeals.
And this is a screening process that's supposed to weed out the panel of the Court of Appeals is supposed to weed out the frivolous applications.
That's
essentially,
correct.
And only let those that might conceivably have some merit go forward.
That's correct. So, and I would note that the options for either a review in the Court of Appeals, which would be a sua sponte rehearing or en banc, or certification by a Court of Appeals to this court, are things that are done when judges decide that this is sufficiently important, not when a prisoner decides to petition.
Justice Sotomayor?
Counselor, we haven't gotten back to the main question that amicus has addressed. You agree with Petitioner that 2244B1 applies only to state prisoners, the same claim litigation bar, correct?
That is correct, although we may have slightly different reasons for concluding that. I think some of it overlap, but they don't apply onto all of our...
But you disagree with amici position.
That's correct.
Why don't you just summarize why you disagree with amici?
Well, I think there's I'll give you a preface, and then I'll jump to I think a more dispositive point. First, when you look at the language that's used in B3 and B4, the language is distinctive from B1 and B2. It uses second or successive application, and it uses authorization language. Both of those map directly onto what H is doing. That is bringing a federal prisoner.
Just go back to it.
And then the second point is, even if most of the amicus's argument turns on the fact that B3C says you look to the prima facie requirement with respect to the requirements of this subsection. Subsection B includes B1 and B2. Even if you accept that you look to the subsection, when you look at B1, by its own terms, it only applies to a habeas corpus petition under Section 2254.
So
it just wouldn't even apply on its own terms, even if
the bottom line is you agree substantively that the Court of Appeals, the District Court and the Court of Appeals, or the Court of Appeals, did not subject this to the proper review. It should have reviewed it under.
Yes,
20,
and this has been the department's position before any court of appeals took that.
All right. Yes, you've been saying that from the beginning. But you're claiming that this is unlike Castro and that we don't have jurisdiction even under the narrow reading, which is the Castro reading by your
That is correct.
By your adversary.
That's correct.
Does that make any sense? There has
Yes.
been no review of the merits of this case at all by the Court of Appeals.
Justice Sotomayor, the jurisdictional inquiry does not look to whether there's an error and then decide
No,
whether
they
to have
used it
jurisdiction.
that way. They refused to apply 2255H by dismissing the case. They didn't deny the application as not newly discovered evidence or not a new rule of constitutional law. They dismissed the case instead of denying it because they said they lacked jurisdiction.
That seems to support my point. Their point was not that it doesn't, we're not going to address whether he's right or wrong, the prisoner's right or wrong. We just lack jurisdiction. The same thing is true here.
Well, if they didn't lack
inquiry does not
jurisdiction, they got the ground wrong. That's what basically
I've not
Castro
seen any
was saying.
decision by this court that
By the way,
concludes that
there's no question that if he goes back down and they look at it substantively, they'll probably boot him out anyway, but it wouldn't take care of the circuit split.
It wouldn't, but as we've discussed, there are other ways to take care of that. Just because this vehicle comes to you doesn't mean you need to pull the trigger immediately, particularly when there's a jurisdictional bar that would, if you rule against us on the broad ground at least, would triple the number of filings by prisoners.
No, it wouldn't, because all that would have to happen is that circuit courts would just say, we're granting or denying under H, and that's clearly barred. That's what they should be doing anyway, but they're not doing. Some of them are using the state habeas substantive provisions instead of the federal habeas substantive provisions.
Well, we agree that there's an error there, but I don't think that error...
There wouldn't be an increase in filings. Castro hasn't increased our filings. They would just do what they're supposed to do. Say under H, deny.
Well, that's because Castro is only the question of whether it's second or successive, and in this case, there's no question it's a second application. It would be his second.
But it would only be with respect to B1, a ruling by us.
Justice Kagan? Justice Gorsuch?
Just real briefly, Mr. Yang, on the merits. You ask us to read all of B, 3, A, B, C, D, and E on jurisdiction as of piece. But on the merits, you ask us to split up B. So you say don't split up 3 on jurisdiction, but split up on the merits B. And you say B3 and 4 apply, but B1 and 2 don't. And one of the arguments, main argument, as I understand it from you, is because the first two mentions Section 2254. But the same question I had to Mr. Adler. Why doesn't that cut against your view on the merits, given that this provision, B, is all about all habeas, pre- and post-conviction, federal and state? You agree that that's the case. And
I'm sorry, do you mean all of B or just B3 and B4?
Well, B, 3 and 4 are all about all applications. Everybody. Yep. Everybody's in, pre and post. And what the inclusion of 2254 tells us is that that's addressed to post-conviction applications. Why isn't that a natural understanding that it's actually more applicable in the 2255 context? We have to read motions as applications anyway under your reading. Why aren't these the most relevant applications for federal prisoners?
2255 is post-conviction, too.
I understand that. That's my point.
I guess I'm confused because
right.
Congress has chosen... Congress chose distinct language here.
Yes, I understand that. And I'm asking why. That's all right. I'll ask amicus.
Thank you. Justice Gorsuch? Justice Barrett? Justice Jackson? Thank you, counsel.
Thank you, Your Honor.
Ms. Mitchell?
Mr. Chief Justice, and may it please the Court, on the one-year anniversary of Timothy McVeigh's bombing of a federal building, Congress passed AEDPA to advance the finality of criminal convictions. Congress largely did away with post-conviction applications by federal prisoners, requiring them to file motions under Section 2255. And Congress amended Section 2244 to provide finality requirements for state prisoners who largely seek post-conviction relief via an application under Section 2254. Everyone agrees that Section 2244 is principally about state prisoners, and that there's a cross-reference that makes it applicable to federal prisoners. That structure means that there is going to be language in 2244 that is specific to state prisoners. And you have to read that in light of a cross-reference that makes language about state prisoners apply to federal prisoners. Everyone agrees that the cross-reference incorporates 2244 B3C, which says to apply the requirements of this subsection, subsection B. And the very first requirement of subsection B is the do-over bar. That interpretation follows from simple statutory cross-references. It also makes perfect sense in light of Congress's clear goals. There is no reason to think that in the landmark legislation passed in the wake of the Oklahoma City bombing, in which Congress was trying to focus on finality, it entirely eliminated any do-over bar on post-conviction motions by federal prisoners like McVeigh. I welcome the court's questions.
Ms. Mitchell, both the government and petitioner, though, put more weight on the difference in language in 2255 and 44. The language application versus motion, that there's more emphasis on habeas for state prisoners. How do you reconcile that, the difference in language?
Justice Thomas, the way you reconcile this is because you're viewing this statute via the lens of a cross-reference. I think this is really important to understand what both the government and petitioner are arguing. They're saying that when you see the word application, on its face, it includes federal motions. That carries significant consequences for AEDPA. In the statute of limitations provision, for example, 2244 D1B, Congress distinguished in the state context filing an application. In the statute of limitation provision governing federal prisoners, 2255 F2, it used different language. It said an impediment to making a motion. That application and motion distinction was critical to AEDPA. Both the petitioner and the government say, well, we're just going to read application to mean motion, and I don't think you can do that. Application means application. You apply it to motions via cross-reference. And that's why, to Justice Gorsuch's question, the under 2254 language makes it a closer fit to 2255 motions than the general provisions in subsection B3. B3 speaks only of applications, which on its face excludes 2255 motions. In addition to rewriting motion to mean application, both the government and the petitioner want to rewrite the language this subsection. And again, that has sweeping consequences not just for AEDPA, but for the U.S. Code. One of the principal decisions that my brief relies on is the Cyan decision, where this court said clearly that when Congress means subsection, says subsection, it means subsection.
But why wouldn't we take that to be right in the category of the very first thing that you said, which is we all agree that this 2244 primarily applies to state prisoners, and that there will be language as a result that might not be a perfect fit because it's directed to state prisoners. And I would think this subsection is that kind of thing.
I don't think so, Your Honor, because this subsection is direct command of the cross-reference, and it says to apply all of B, and that's part of the very provision that everyone agrees is incorporated.
I understand, but your view of this makes us think that Congress was trying to get to B1 in the federal context through two cross-references. That seems like such an odd way. I mean, if Congress wanted the B1 bar to apply in federal habeas scenarios, they easily could have just written that, or in H, they could have directly referenced B1. But you get us there through the cross-reference in H and then the cross-reference in B3, and that just seems so strange.
I think that's the easiest way to do it in light of all of the parties' agreement that B3C applies. But there's another path, which is just to say on its face, it's a requirement that applies via the cross-reference, because the cross-reference says as provided in 2244, and you're going to bring in subsection B1, which isn't displaced by H1 and 2, which applies. I mean, we think the better place is to start where all the parties agree, but I'm not going to resist a reading that would bring it in on the as provided in 2244 cross-reference alone.
Thank you.
In addition, just to home in on the problems with reading subsection to mean something else, not only did this court confront that in the Cyan decision, which neither the government nor the petitioner even cite in their reply brief, but it's been an issue in numerous other cases that this court has confronted, including with respect to the Federal Vacancies Act in NLRB versus Southwest General and throughout. We also know that in AEDPA, Congress knew how to specify and pick and choose provisions when it wanted. So for example, in 2264B, Congress said, following review, subject to subsections A, D, and E of section 2254, the court shall rule on the claims properly before it. So there are other examples in AEDPA where it picked and decided to pick and choose among subsections, and it was specific. Here, Congress enacted in a wholesale cross-reference with respect to, at a minimum, the certification provisions that all agree include B3C.
What do you make of the fact that Congress, to your alternative point to Justice Jackson, that Congress didn't just end it, 2255H, after as provided in section 2244? They could have just ended it there, and then the cross-reference would have been complete, I think. And what are we to make of that other language, if anything?
They could have done that. There are two reasons why I think they didn't. The first is because they were bringing over the certification procedures. And the second is they wanted to provide constraints on the abuse of the writ, which is what H1 and 2 principally address. So in the pre-EDPA context, there were two problems that the court faced with habeas corpus applications. One was the successive problem. So you have someone who's bringing a claim that they brought again. A separate and distinct problem was abuse of the writ, which is where you held on to a claim, you brought one, waited, you brought your other one and another one in a second application, you'd bring a third one. That was a distinct problem, abuse of the writ. And in 1948, when Congress amended AEDPA, they added in 2255 a successive bar. So what Congress said was the sentencing court shall not be required to entertain a second or successive motion for similar relief on behalf of the same prisoner. This was in the 1948 Act. This court interpreted that language in Sanders to say, Section 2244, and this language is addressed only to the problem of successive applications. And what the court did is said, well, we're not going to read that to read out the abuse of the writ doctrine. So this is addressing successive applications, and we're also going to apply abuse of the writ doctrine. The provisions in 1 and 2, which are now after the 2008 technical amendments H1 and 2, only address abuse of the writ. So there's no reason to think that when Congress omitted that language and instead put a cross-reference to 2244, that it meant not to include the number one finality promoting provision, which is B1. Additionally, there's some argument that the government and the petitioner make that this is really not a problem, kind of what are we doing here? But Judge Rosenbaum in the 11th Circuit observed that in the 3 months after this court's decision in Welch, the 11th Circuit saw 1,800 applications for Johnson-based review. So I do think it is a real problem that courts are grappling with. And the tools that Congress gave the courts of appeals to deal with this problem allowed it to make the expeditious determination under the 30-day clock. And what petitioner and the government would say is, well, we're going to take one of those key tools out of their tool belt. We're not going to allow them to look and see, was this argument already presented? And if so, can we dismiss it on that basis alone? And that makes it more difficult to accomplish its task in 30 days. I think one thing is significant about that also is Congress provided the same 30-day clock for state prisoners and federal prisoners. It didn't say we're going to give 30 days for state prisoners and 45 for federal, or some other indication that they intended to treat them differently. And Justice Thomas, to your question to the petitioner, all indications by use of legislating by cross-reference is that Congress wanted to treat, at least for successive applications, state prisoners and federal prisoners alike. That's why they chose this kind of clunky mechanism to do so via cross-reference. One additional point, Petitioner, in response to one of the questions about jurisdiction, said that there's a clear statement rule as it relates to state prisoners, with the jurisdictional point, because of the word application in 3E. That's significant because that is saying that is a clear statement that this applies to state prisoners, which is exactly our point. Every time Congress said application, it was excluding on its face federal motions. So in order to read any of these provisions as applying to federal motions under 2255, you have to view them in light of the cross-reference. And that's exactly what you do when you look at 3C's cross-reference to B1. You read that language, a successive habeas corpus application under 2254, in light of that cross-reference to apply to similarly situated federal prisoners. And again, Justice Gorsuch, to your question, it's not like it says applications by Guantanamo detainees. I think my argument would be harder if the additional language was something that didn't map on so tightly to the 2255 mechanism, but instead that's a closer fit than the application language that the government and Petitioner rely on to bring in the certification provisions in the first place.
Which can include pre-conviction detainees.
Yes, Your Honor.
Yeah.
And so it's just a natural fit to see what Congress was doing there. Again, in the wake of Oklahoma City, there's no reason to think that the number one finality provision in 2244, which was titled Finality of Determinations, that they intended that not to apply to federal prisoners like McVeigh, which was the exact target of the one-year anniversary when President Clinton signed this bill into law.
It was an implicit repeal of a power federal courts had previously to prevent do-over petitions by federal habeas petitioners.
Exactly. And instead, they rooted them through the provisions for 22, provisions that otherwise applied to state prisoners. And one important point, the standalone language that prevented successive applications by federal prisoners had long been marginalized by this court. In Sanders, the court said, this can't be taken seriously. And so it's perfectly natural for Congress to say, you didn't do what we said in 2255, and instead this time around, we're going to put you in the same bucket as state prisoners where you will enforce the successive bar. And the combination of B1 together with subsection 1 and 2 in 2255 addressed both the successive and the abuse of the writ problems that Congress was targeting in EDPA.
Thank you, Justice Thomas. Anything further? Justice Alito? Justice Sotomayor?
Counsel, collateral estoppel would apply to successive petitions in federal court. So you get to the same place, just a different issue. And as quick.
That's not true, Your Honor. There are decisions by this court saying that res judicata does not apply in the habeas context. And instead, what 2244 and 2255 did was, and this is in the legislative history, was to codify a modified res judicata principle. So res judicata traditionally has not applied in habeas.
Justice King, Justice Gorsuch? Justice Kavanaugh? Justice Barrett?
No.
Justice Jackson? Thank you, counsel.
Thank you.
Mr. Adler, rebuttal.
Thank you, Mr. Chief Justice. We acknowledge that this is a technical case, but I'd like to try to simplify how the court should resolve it if it agrees with us on B1, which we do believe is resolved on the face of the provision. This is the rare EDPA case where the plain text of the statute resolves the question. So if you agree with us on B1, then on the jurisdictional question, there's two options, I think. One is the government's late-breaking suggestion on page 12 of its reply brief that to dismiss this case for lack of jurisdiction and indirectly resolve the B1 question. This goes to Justice Barrett's suggestion earlier. Our concerns with that remain that there is a significant risk that doing that would not resolve the circuit conflict unless the court is crystal clear that it is purporting to resolve the B1 question in a holding. We also have significant concerns about whether Mr. Bowe, of all people, could benefit from that. We appreciate the government's suggestion that he could refile. However, we are not sure about that in light of some language in the Bradford decision, 11th Circuit, that says the B1 dismissals are with prejudice. And if anybody should benefit from a statement by this court on B1, it's Mr. Bowe, who has been waging a 3-year campaign designed to eliminate this atextual obstacle that has been placed in front of him. So that's one option. We think it is highly unorthodox and can be avoided simply by accepting one of our narrower jurisdictional arguments, and we have given the court 3 of them. We think the clear statement rule applies to all of them. I don't understand how the government can say there's no clear statement rule when Castro says it on this particular statutory provision. We don't have to do 2 steps. It's right there on the face of the opinion. And by the way, the case it cites for that is not Utah versus Walker. It is Felker versus Turpin, which is a habeas case. It says no implied repeals of habeas jurisdiction. The court applies it here to B3E. Justice Jackson, I think you have identified the simplest way to find jurisdiction over this case, and it is the fact that the Court of Appeals dismissed this without ruling on the merits. It did not grant or deny. The text of B3 is very clear that we have grants or denials and we have dismissals. The court here dismissed this case improperly. That's not the error that we're complaining about. That would be harmless because the effect would be a denial. But it is the reason why there's jurisdiction. There's no denial here. That follows directly from this court's B3 precedent in Stewart, which also involved the dismissal, no merits ruling, and the court said the effect, even though it was to grant it, didn't matter. It wasn't a grant. And the final thing about that, if the court simply clarifies that, in this opinion, that courts of appeals should not be dismissing claims in this posture, but should instead be granting or denying them, then the court will not see a single cert petition under that theory come to this court, because the courts of appeals will simply grant or deny moving forward. And so if the court is concerned about receiving additional cert petitions under the statute, that's the easy way to go. And so at the end of the day, we think the text of B1 is plain. This court has jurisdiction to effectuate that text and resolve the circuit conflict directly once and for all. Thank you.
Thank you, counsel. Ms. Mitchell, the court appointed you to brief and argue this case as an amicus curiae. In support of the judgment below as to question 1, you have ably discharged your responsibility, for which we are grateful. Thank you. The case is submitted. We'll hear argument next this morning in Case 24-482, Ellingburg versus United States. Ms. Saharia.
Mr. Chief Justice, and may it please the Court. The MVRA classifies restitution as criminal punishment and is thus subject to the Ex Post Facto Clause. Just like imprisonment and fines, restitution is part of an offender's criminal sentence, imposed at the end of a criminal proceeding as a consequence of conviction. The sentence is the punishment for the crime. Other features of the MVRA confirm this conclusion. Restitution is intertwined with other punishments and can be the only punishment for misdemeanors. Like fines, restitution is enforced with the threat of summary imprisonment, and the federal rules of criminal procedure and the chapters of Title 18 that govern sentencing apply. All of this is why, in a trio of cases, Paroline, Pasquantino, and Kelly, this court called restitution a criminal punishment that serves punitive and penological purposes, and a criminal sanction that furthers the government's interest in rehabilitation and punishment. Amicus responds that victim compensation is the primary purpose of restitution, but that purpose-based analysis overlooks the threshold classification question Does the statute on its face impose criminal punishment? The answer here is yes. Criminal punishments may serve multiple purposes at the same time. Imprisonment punishes, but also protects the public. The same is true of restitution. It punishes the offender, and if the offender pays, compensates the victim. Finally, this case presents the question presented. The MVRA is the law being applied to petitioner retroactively. The district court that denied the show cause motion applied the MVRA, and the Eighth Circuit then affirmed on the ground that the MVRA imposes a civil remedy. The petition challenges that case dispositive holding. I welcome the court's questions.
Aren't we going to have to wrestle with the fact that petitioner was not originally sentenced under the MVRA?
We don't think the court needs to wrestle with that fact, and I'll start by saying it's not clear what statute the original sentencing court applied 30 years ago. All we have is a judgment form. The judgment form simply imposes an amount of restitution, and there is one portion of the judgment form that at Pet App 27A that cites to Section 3663 in one paragraph, but the checkbox in front of that paragraph is not checked. So there's nothing in the judgment form that indicates that whether the district court that sentenced Mr. Ellingburg applied the VWPA or the MVRA. Now, under the rationale of the decision below of the Eighth Circuit, the MVRA was the statute that governed the restitution order imposed at sentencing, because the Eighth Circuit held, at the urging of the government in this case, that the MVRA imposes only a civil remedy. As a result, under the effective date provision of the MVRA, it was in effect at the time of the sentencing, and it applied because there was no constitutional barrier to its application. That is the rationale that the government argued to the Eighth Circuit below. The Eighth Circuit accepted that argument. The government continued to argue that in its brief in opposition to our cert petition at page 3, where it again said that the MVRA was the statute that governed this restitution order.
And isn't your key point that regardless of what happened 30 years ago, today your client is being held to the responsibilities of the MVRA?
Absolutely, Your Honor.
So, you still, I would think, have an ex post facto argument because no one disputes that the MVRA was not in existence at the time he committed the crime.
Correct. We all agree that the statute that is being applied retroactively is the MVRA. Correct. We couldn't make an argument that the VWPA was applied retroactively. That was in effect at the time of the offense in this case.
And of course you would win if you did, because then he couldn't be held to the very provision that you are trying to get nullified.
That is the argument that we will make on remand if we end up on remand. I think the government takes a different position on that issue. They think that the MVRA liability period provision can apply even if the restitution order was imposed under the VWPA. But that would be an issue for the Eighth Circuit to resolve on remand. Now, on the merits, I will just start by saying that it's crystal clear that restitution is part of the criminal sentence. This court said that in Manrique, and there are a number of textual indications of that fact in the statute, starting with Section 3556, which is in the chapter entitled Sentences. That provision instructs courts to impose restitution in imposing a sentence on a defendant. It then points courts to 3663 for discretionary restitution and 3663A for mandatory restitution, both of which instruct courts to impose restitution when sentencing a defendant. In numerous parts of the code, Congress used the language, a sentence of restitution. For instance, in 3611, it said a person who has been sentenced to pay a fine, assessment, or restitution. Sentenced to pay restitution. And it makes sense that Congress made restitution part of the sentence because it viewed restitution as a punishment that had consequences for other criminal punishments.
Section 3664M allows victims to enforce restitution as a judgment lien under state law. Are you aware of any criminal punishments that victims can enforce personally?
No, I think this is probably the only one. The MVRA gives victims a very limited right to enforce restitution by obtaining a lien on property within the state where the conviction was imposed. It does not give victims the full range of civil enforcement mechanisms, such as garnishment, for instance. It does give that full range of enforcement mechanisms to the Attorney General. The Attorney General has the same authority to collect restitution as she does to collect fines. And it's telling that Congress treated restitution just like criminal fines. Doesn't
the fact that the victims can enforce the restitution order themselves cut strongly against your argument that restitution is penal rather than looking to provide remedies for the victims?
I don't think so when you look at the entirety of the statutory scheme. Again, first, the fact that it is part of the sentence. Second, that the sentence can be enforced not only through civil liens, but through the defendant's freedom. This court made that point in Pennsylvania Department of Welfare versus Davenport, where it noted that restitution obligations differ from ordinary civil obligations because they are secured by the defendant's freedom. In Section 3614, Congress authorized courts to impose any term of imprisonment that may have originally been imposed as a resentence in cases where defendants fail to pay both restitution and criminal fines.
Is there any reason you can't have a civil proceeding running parallel to the criminal proceeding? You know, the state has an agency to allocate fault in the case of auto accidents, and whoever has to pay, and somebody steals a car and, crashes the car and he's criminally prosecuted for that. And in the same accident, just has to go through a civil process where he may also be assessed a fine. Is there anything wrong with that?
No, I think Congress could have chosen to do something like that. Now, depending on how it was structured, that may raise some serious problems under the Seventh Amendment. But putting the Seventh Amendment consequences of such a scheme aside, Congress might have created such a system, but that's not what it did here.
Could it just say, we intend this to be civil and have the operations of the statute operate in the same way, and then we would say it's civil? In other words, it seems odd that so much turns on the label as opposed to the operations of how the statute works.
Well, I think if Congress perhaps just said the word civil but did everything exactly the same, we would still be before you arguing that that is quintessential criminal punishment. But this court has said that the inquiry at the first step of the criminal punishment—
Quintessential why? If it's payment to the victim, just like a tort suit. I know some of the folks have characterized this as just a tort suit-like.
Sure. I think if it's still part of the sentence that is imposed by the sentencing court as part of the sentence, together with imprisonment, fines, probation, all of the other criminal punishments, I think our position would still be that is criminal punishment. But Congress could have written a different statute that would have accomplished something civil, again, wrestling with the Seventh Amendment consequences of that. The Seventh Amendment is, I think, important here because it is part of the backdrop against which Congress legislated in the MVRA. In the wake of the VWPA, which was the predecessor to the MVRA, the courts of appeals uniformly rejected Seventh Amendment challenges to restitution on the ground that restitution is criminal punishment. This court commented on that uniform consensus in Kelly versus Robinson before Congress enacted the MVRA. This court also construed the VWPA in Huey before the MVRA and applied lenity to the VWPA as a criminal statute. All of that is part of the backdrop against which Congress enacted the MVRA. And not only did Congress not do anything to signal it was intending to depart from that consensus, but it carried forward the same operative language from Section 3663 in the VWP.
And in its legislative history, didn't it seem as though Congress was pretty clear that this was not just about compensating the victims? I mean, I see here a quote that Congress says that the MVRA is, quote, needed to ensure that the loss to crime victims is recognized and that they receive the restitution that they are due. It is also necessary to ensure that the offender realizes the damage caused by the offense and pays the debt owed to the victim as well as society. So it seems as though, at a minimum, Congress was doing more than just saying the victim has to be compensated. And if that's the case, why is it characterized as a criminal statute if there are two motives operating?
Sure. May I answer?
Please.
So to take those questions in two parts. First, absolutely, Congress made crystal clear in the legislative history that it thought the MVRA was a criminal statute. If you read the Senate Judiciary Committee report, it uses the word criminal more than 40 times, and the only time it uses the word civil is to distinguish restitution from civil proceedings. Now, to take the second part of your Honor's question, the inquiry that this court has adopted for when is something criminal punishment just asks whether Congress intended to create criminal punishment and whether it has some other purpose, such as here compensation, such as in the case of imprisonment, protecting the public, doesn't matter because all punishments serve more than one purpose.
Thank you.
Thank you. Justice Thomas? Justice Alito?
What will be left of Smith if we rule in your favor? Suppose that a state sex offender law provided that the sentencing judge would determine how long an offender needed to register. Or suppose that the state could summarily revoke probation if a defendant failed to maintain his registration. Would that mean that the sex offender law would be penal?
Not necessarily, Your Honor. We don't think there's any inconsistency between a holding in our favor here and Smith. In Smith, the requirement to register as a sex offender was not imposed as part of the sentence. The legislature used the sentencing process simply to notify the offender of the need to register, but it was not imposed as a punishment. There is a distinction between the sentence itself and conditions of release or probation. Those are conditions on the sentence, but are not the sentence itself. So we don't think that a condition of release, such as the obligation to register as a sex offender, would necessarily amount to criminal punishment in the same way that conditions of imprisonment, like cell phone restrictions, are not themselves punishment.
Would you say that the primary function of restitution under this statute, the statute you would like us to apply, is penal or civil?
We think
the primary function is the primary function to punish, or is the primary function to provide compensation to make victims whole to the extent possible? Which is primary?
The court in Paroline said the primary purpose is compensation, but we think the penal purpose here is just as important and primary, I would say, as the compensatory purpose.
Justice Sotomayor?
Under the statute, drug offenses order restitution to the society, don't they?
Yes, and we think
so. That's why you're saying it's equal.
Yes, that's a very good indication that Congress was intending to do more than simply compensate individual victims.
Number two, our ex post facto jurisprudence has three components. Was it being applied to previous conduct? The first is the question before us, is it criminal or civil? But that there is a third component, does it increase punishment? On that question, there's a circuit split, and we didn't grant cert on that, correct?
That's correct.
So this, at worst, would be a reverse remand.
Yes, we agree with that, and I think the government does as well.
Okay. Thank you.
Justice Kagan?
What about these provisions that say that on the one hand, the award is offset by any civil judgment received, and on the other hand, that the victim can keep coming in, however many years later, to offer proof of further damages. That really, both of those seem very odd if the statute is primarily punitive.
Sure. So as to the first one, we think that feature of the scheme supports us as a matter of statutory construction, because those provisions, which are in 3664J and L, distinguish between what happens at sentencing, at the imposition of restitution, and what happens in a subsequent civil proceeding. And the fact that Congress used the word civil proceeding and those particular provisions, we think makes quite clear that it understood that what is happening at sentencing when restitution is imposed is not a civil proceeding. Now, as to the second point, the fact that victims can come back at future points, first, that is cabined by a good cause requirement. There needs to be some reason why that was not presented to the sentencing court at the time of sentencing. But putting that aside, we think that one particular feature of the statute, similar to the narrow opportunity to obtain a civil lien, just doesn't overcome all of the indications that Congress understood it was imposing a sentence.
Thank you.
Justice Gorsuch? Justice Kavanaugh? Justice Barrett? Justice Jackson? Thank you, counsel. Ms. Robertson?
Mr. Chief Justice, and may it please the Court, Congress implemented restitution under the Mandatory Victim Restitution Act as criminal punishment. The text makes plain, first, that restitution is punishment. In the statute's terms, it is a penalty or sanction. And Justice Alito, to your question, that fact alone distinguishes restitution in this case from the registration requirements at issue in Smith v. Doe, which the Court held wasn't punishment at all. Then the Court has to consider whether this is criminal or civil punishment, and we think the text is equally plain that it is criminal. Restitution is imposed for a criminal offense on a criminal defendant at criminal sentencing where the United States stands as the adversarial party. And if there were any doubt, the statutory history dispels it. The Court of Appeals had uniformly held that restitution under a predecessor statute was criminal punishment, and Congress replicated the relevant language in the MVRA and doubled down on features indicating a punitive intent. This Court should vacate so the Court of Appeals can consider in the first instance the United States' alternative arguments for affirmance. I welcome the Court's questions.
Does it make a difference if this sanction was imposed in a separate proceeding?
Does it make a difference if it had been imposed outside of the sentencing context? Well, I don't think it would change the nature of restitution as punishment, given that Congress refers to it as a penalty, but it might change whether we conceive of it as a civil penalty, like the administrative penalties at issue in Hudson or in Ward, or whether we consider it a criminal punishment. The fact that this penalty is imposed in a criminal proceeding is one strong indication that it is meant to serve as criminal punishment.
Do you think that all sanctions imposed in criminal proceedings are, in fact, penal or criminal?
So I think this is an important distinction, Justice Thomas, and I want to be clear that we do distinguish between what is part of a criminal sentence and what occurs at criminal sentencing, because we agree with amicus that not everything that occurs in criminal sentencing or even that appears in a criminal judgment is necessarily part of the punishment and therefore part of the criminal defendant's sentence. So the classic example here would be the registration requirements at issue at Smith versus Doe. Because those requirements were announced at sentencing, they even appeared in a judgment, but that didn't make them part of the sentence because they weren't meant to add to the defendant's punishment at all. So here, it is quite important to our analysis that Congress has specified that restitution itself is meant to serve as a penalty or a sanction. And that is a point that we would hope that the Court would be clear on in its analysis, because we do think that there are things that might come up at criminal sentencing, including conditions of supervised release, that we wouldn't conceive of as punishment at all. So we do think that when the court engages in the statutory construction here, it is paramount to us that Congress labeled this as a penalty or a sanction, and that we think that that really washes away many of amicus's arguments about the non-punitive purposes that restitution might serve, because of course we agree that restitution can serve important compensatory goals, but when Congress has told us expressly that it intends restitution to be punitive, it intends it to be a penalty, that answers the question as a matter of statutory construction.
Just to summarize, what should we say, in your view, in the opinion, to prevent spillover effect that you're concerned about? What are the key components?
So we think there would be two important points for the court to make in the opinion. First is to be clear that it is resolving this as a matter of statutory construction under Step 1, not under Step 2 of the Mendoza-Martinez test, because we do think restitution is the type of penalty that can be implemented as either criminal or civil, and Congress and state legislatures have chosen in some circumstances to implement restitution as a civil penalty. So we think a decision that makes clear that the court is resting on a matter of statutory construction under the MVRA will leave appropriate room for legislatures in future cases to treat restitution as civil. When it comes to statutory interpretation, we think it's important that the court not single out any one particular feature that makes restitution a criminal punishment. Rather, we think it's important both that the text is plain that it is punishment. As I said, it's referred to as a penalty. Elsewhere, it's referred to as a sanction. Elsewhere, the text refers to defendants who are sentenced to restitution or a sentence of restitution. And then when it comes to the question of whether it's a criminal punishment, it's important to us that all the textual clues here point in the same direction. And that includes that restitution is predicated on a criminal conviction, that it's imposed personally against the criminal defendant, that it occurs at criminal sentencing, that for misdemeanor offenses, it's the only punishment a defendant might receive, that it's the United States that is the adversarial party that can enforce restitution and the obligation to impose restitution in the first instance, and then exercises the primary authority on the back end, and then on top of all that, that restitution is codified within the criminal code.
So if I can paraphrase, Ms. Robertson, your suggestion to us is that we throw in absolutely everything so that in some future case we will be sure to have some sort of distinction.
I think our test here is consistent with any ordinary principle of statutory construction, which is we don't want to suggest there are hard and fast rules here. And yes, we do
just
think—
say yes. You can just say yes.
We do think it's important to rely on all the textual clues.
Well, what about the prior statute? Was that punitive too?
Yes, we do think that restitution under the VWPA was criminal punishment. The government took that position.
Well, then what do you have to say about Section 2 of the VWPA, which says explicitly the purpose of this is to help victims?
The reason that the government took the position when this question was litigated that the VWPA was a criminal punishment is because that statute uses similar language to the one at issue here. It does refer to restitution as a penalty. There was also plenty of statements within the legislative history there that Congress intended
legislative history. In the statute itself, Congress lamented that the criminal justice system had ignored the physical, psychological, and financial hardship of victims, found that the criminal justice system focused only on identifying and punishing offenders. As a consequence, victims had lost valuable property to the criminal. Congress enacted with that act with the stated purpose of ensuring that the federal government does all that is possible within limits of available resources to assist victims. If this turns on congressional intent, how much clearer could congressional intent be than that, in the statute itself?
We would draw a line between whether Congress intends something to be punishment and the purposes that a particular punishment might serve. It's not unusual, for instance, for criminal fines to serve a compensatory purpose. By statute, most criminal fines are obligated to the Crime Victims Fund. So we do think that a punishment can serve a compensatory purpose, but there's still the threshold question of whether Congress intended to implement the measure as a punishment. And for purposes of
I thought the question was congressional intent. If Congress says our intent is to assist victims, isn't that open and shut then?
Well, we think the fact that Congress refers to restitution as a penalty is similar to saying restitution is punishment, and there's no plainer statement of intent than that from the text. But for purposes of this case, I think it is important that whatever questions might have existed about the VWPA when it was first enacted, the courts of appeals uniformly treated VWPA as criminal punishment. That's a consensus that this court observed in Kelly. Congress was legislating against that backdrop.
Maybe they were right, maybe they weren't. Maybe they, like possibly you, are worried about the consequences of saying that it's not penal. But then you have the VWPA followed by the MVRA, the Mandatory Victims, talks expressly about victims. Doesn't that show what Congress is getting at?
Again, we don't want to gainsay the important role that victims play in Congress's motivation here, but just as to the threshold question, we do think Congress's intent to implement criminal punishment is clear. And as to the consequences, there is a real consequence to treating restitution under the MVRA as a civil penalty, and that's the concerns that it would implicate the Seventh Amendment. We think that was the concern that was outlined.
Ms. Robertson, I just wanted to ask you analytically, and I'll show my cards and say it's just because of thinking about this DIG argument. Do you think analytically we should be thinking about these as two distinct statutes, or should we be thinking about the VWPA and the MVRA as just different amendments to the same basic statute?
We think that you can think today of both Section 3663 and 3663A as part of the MVRA because restitution imposed under either scheme would be subject to all of the MVRA's many provisions, including its collection authorities, its procedural safeguards, and all of those provisions are relevant to the court's analysis. But to be direct about the DIG, if the court wants to identify the provision at issue here, we do think it should take the case on the premise that it's Section 3663A. That was the government's position before the Court of Appeals. The Court of Appeals accepted that premise. Petitioner is no longer disputing it or asking this court to revisit that factual predicate. And so we think it's appropriate for the court to resolve this case on the same basis that we asked the Eighth Circuit to rule in our favor below.
And that section was not in effect when he committed the crime, correct?
That's correct.
So that's the source of the ex post facto problem. No matter what happened at sentencing, at the time he committed the crime, 3663A was not in effect, and today he's being held to account under that provision.
That's correct, Justice Jackson. I would make one clarification. The MVRA by its terms applied to petitioner. So if the district court didn't apply 3663A, it could have only done so if it determined that that provision was criminal punishment, the very question at issue here. Now, there would be a separate question as to whether the limitations period that the government is currently attempting to apply to petitioner might constitutionally apply. It's our position that it could, even though his restitution obligation was criminal punishment, because we don't think increasing the time to collect restitution increases his punishment.
That's the argument you want to preserve.
But that's the argument we're trying to preserve for remand.
Can I just go back to Justice Alito's colloquy with you? Because I guess I'm still wondering whether your argument flows from the idea that there might be different purposes of punishment and that you could have a punitive measure that is imposed for rehabilitative circumstances, and with an idea that you are making this person pay back society, you're making this person make amends for what it is that he's done, but it really is still a part of the punishment in the way that theorists have traditionally understood various purposes of punishment.
We think that's right, and this court made a similar observation in Kelly itself, where it said that restitution serves as a particularly effective rehabilitative penalty precisely because it forces the offender to confront in concrete terms the harms that his actions have caused to a real person, more than a fine, which is paid to an abstract entity like the state would. It also serves a particularly effective deterrent purpose for that reason, by closely aligning the punishment that the defendant faces with the harm that he's caused.
So even if it's victim focused, it can still be punitive in this way.
Yes, absolutely. And we do think that this punishment here serves penological goals as well as compensatory ones.
Thank you.
With respect to our opinion, if we rule in your favor, you also want us to say something about the Sixth Amendment, or to avoid saying anything problematic about the Sixth Amendment, correct? What do you suggest?
We think that the cleanest way to resolve this case when it comes to constitutional avoidance is to recognize that constitutional avoidance only comes into play where, after exhausting all the ordinary tools of construction, the court is left with competing interpretations that are plausible, and one would avoid constitutional concerns. Here, we don't think that there are competing plausible constructions. We think that Congress's intent is unambiguous. We also don't think that there's a construction that would avoid constitutional concerns, because calling restitution a civil penalty would raise Seventh Amendment.
You might be referring to the Seventh Amendment.
Yep.
My question was about your footnote about the Sixth Amendment.
Right. So we don't think that the court would only need to address the Sixth Amendment if there were a legitimate claim to be made for constitutional avoidance. And we simply think that there's no legitimate claim here because there are constitutional concerns on either side. Of course, even if the court agrees with us that restitution is criminal punishment, we have alternative arguments for why restitution wouldn't implicate this court's decision in Apprendi, which we would continue to make.
Right. That's what I was getting at.
Justice Thomas, anything further? Justice Alito? Sotomayor? Justice Kagan? Justice Gorsuch?
Even if this were civil retroactivity is not something that we countenance without a clear statement, right?
So we think that the court has been clear that the Ex Post Facto Clause itself only applies to criminal punishment.
Right, you disagree with Professor Logan on that, yes.
Yes, we do. We do disagree on that point. We take the cases.
But we do, Landgraf and other cases, civil retroactivity is something that's antithetical to basic rule of law notions, at least without, in many instances, not always, but Landgraf says that too, right?
So we agree that it would be unusual for Congress to apply either a civil or criminal penalty retroactively, without, of course, a clear statement that it intends to do so. We have that here. Congress clearly intended to apply the MVRA retroactively to the extent constitutionally permissible, and it's important to us that many of the MVRA's provisions can apply retroactively, even though it's criminal punishment, because not all of the MVRA's provisions increase that punishment.
Thank you.
Justice Jackson. Thank you, counsel.
Thank
you. Mr. Bash?
Thank you, Mr. Chief Justice, and may it please the court. I'll take the dig argument I make first, and then I'll move on to the merits. To clarify the dig argument, and this goes to questions from Justice Thomas, Justice Jackson, and Justice Barrett, it's not only that at the time of sentencing, the judgment form said the old statute. The position of the Solicitor General at the time, consistent with the proviso in the statute that said only apply this retroactively to the extent you believe constitutionally permissible, was not to apply the statute in cases like this. The district court found in this proceeding that the sentencing court did not apply the statute on which the question was presented in this case. The Court of Appeals did not disrupt that finding, as far as I can see, and I don't think it would matter if it did. But at page 4A of the PEDAP, the Court of Appeals says the MVRA is being applied retroactively in this case, but what it meant by that was the 20-year extension provision. But Justice Jackson, whether that would be an ex post facto problem turns entirely on what it's extending. So if that provision applied to something that, let's say, this court had already determined was a civil penalty, the mere fact that it's contained in the same statute as a restitution obligation that is assertedly criminal would not make the application of the 20-year provision to the civil penalty into criminal punishment. So I do think, Justice Thomas, that the court has to decide what was applied in this case, because the question presented relates only to the second statute, not the first statute. And Justice Barrett, this is in a context in which, as Justice Kavanaugh noted, congressional intent is one of the key considerations. And the intent behind the 82 statute may have been very different than the intent behind the 96 statute. And just to respond to one more point on this, I think I heard the government say that, well, even if it applied the other statute, it's all part of the same statute now. But remember, what the sentencing court likely did, consistent with the Solicitor General's position, was apply the pre-MVRA version of the VWPA. So it's not as if it applied the amended version, which maybe that would present a closer question on the dig. It applied the pre-MVRA version. I see my yellow light, so I'm happy to take the questions from the court, Mr. Chief Justice.
But it's the considerations between the two different statutes would, on a higher level of generality, be about the same, wouldn't they? I mean, there's not that much difference, and we're not dealing with the increase or in time that it expands at this level. So, what difference would it make?
Justice Thomas, I do think there are some pretty critical differences between the statute. The two statutes, although my ultimate position would be that neither are punitive. But one big difference is that, especially under the earlier version of the VWPA, the sentencing court could not only decide whether to enter restitution award, but decide the amount based on ordinary penological considerations, culpability, the defendant's circumstances, whether the defendant has dependents, and so forth. That is prototypical of the criminal justice system, which focuses a lot on the circumstances of the offense and the defendant. The MVRA is totally different. The MVRA is a pure compensation regime that parallels the tort system. It does not care about the defendant's culpability. It does not care if the defendant has dependents. It's full restitution. That is characteristic of the civil tort system. And so I do think there are differences. The legislative history is very different. The MVRA is way more focused on victim compensation than is the legislative history of the VWPA.
Would it have made a difference had there been a separate proceeding that looked more like a civil proceeding than doing this at the sentencing stage?
I think that would make it an easier case, but I don't think the outcome should turn on it. So let me just put it this way. Virtually every feature of this statute, it's full restitution, no less, no more. There's offsets for civil judgments. The victim can continue to petition indefinitely for further compensation, for example, for medical bills that continue to arise in old age based on an assault. It can be enforced through a civil lien. Even when the Attorney General enforces it, he or she enforces it in the manner of a civil judgment. The defendant has to notify the victim when his or her ability to pay changes. All of those are clearly features of a civil compensatory system. Now, I think if that was set up with a different case number, where what happened is the victim or the Attorney General could take advantage of the collateral estoppel effect of the criminal judgment and just do everything exactly the same, but it had a different case number on it, I think there would be no question that the court would consider it a non-punitive remedy. So I think the question before the court is, if Congress chose, for what I think are pretty obvious efficiency reasons, to fold that compensatory remedy into criminal sentencing, does that make it punitive? Here's why I think the answer to that question is no. When this court has in the past looked at the nature of the proceedings to answer this question, and those were invariably cases in which the proceedings were civil, and so the court said the remedy was civil, there was really no other explanation for why Congress chose that form of proceeding than that it intended the remedy to be civil in nature. That's not true here. Here, there's a pre-existing criminal proceeding that will happen no matter if there's restitution or not in order to impose a criminal judgment and imprisonment and so forth. And there's a perfectly plausible and I think likely explanation for why Congress folded this compensatory remedy into this proceeding, which is way more efficient to get victims the compensation they need
but
to
your
do it all at
argument it just seems to beg the question, right? The question is whether Congress intended this to be a compensatory remedy. We're not sort of asking, well, why did Congress put this compensatory remedy here? We're asking, is this compensatory, meaning civil, or not? And I guess I feel like you're struggling a little bit against the weight of all of the consensus that existed with regard to the VWPA, the pre-existing statute that this statute was amending, everybody thought was criminal. It was all over the legislative history. It was in the statute. No one questioned it. And so I guess I'm asking you, is there some kind of indication that Congress was intending to shift or depart from that well-established understanding when it enacted this statute that was just amending the prior one?
There are substantial indications, Justice Jackson, and here they are. I'd start with the structure of the statute. Under the VWPA, as it existed when those courts of appeals decisions were rendered, the sentencing court could take into account culpability, deterrence, just punishment, the circumstances of the defendant and his or her dependents in deciding not only whether to impose restitution, but in calibrating the amount. In that
right,
respect,
so they made it mandatory. You don't get to take those things into account, but why does that mean that it becomes less criminal?
Because that is the prototypical characteristic of the civil tort system. When you sue somebody for injuring you or defrauding you, and the jury says, yes, they did it, and now we need to award damages, the jury cannot take into account, well, I think this person's going to reform themselves. This was their first offense. The jury cannot take into account this defendant has dependents, and we want to calibrate this. None of that's relevant. The characteristic of the civil tort system is the same as the MVRA, full compensation and no more. So that is why there's a huge difference between the MVRA and both the VWPA and the state system that this court considered in Kelly. Can I just offer you a syllogism that I think makes the point especially clear?
Sure.
So, two propositions, both from this court's case law. One, in a lot of cases going back to Helverine versus Mitchell in 38 and Marcus versus Hess in 43, this court has said that when a remedy is compensatory, it is not punitive. And even treble damages provisions, the court said, well, that's a rough form of liquidated damages.
And I'm sorry, was this in criminal cases or are these civil cases?
These were cases deciding that a remedy was not punitive, I think in the double jeopardy context.
But in the context of a civil action?
These were civil actions, that's true.
Okay.
That's true. That is a distinction here, and I can address that in a second. But this court—
I mean, isn't that relevant? We're in the context of a criminal proceeding, and the court, the sentencing court, is imposing this as part of the punishment.
It's relevant, but as I said to Justice Thomas a few moments ago, I think the nature of the proceedings has been relevant when it gives rise to an unavoidable inference about what Congress intended, but it's very different here where those proceedings would happen either way, and there's an obvious efficiency route.
What do you do with the legislative history for the MVRA where Congress says it is needed to ensure that the loss to crime victims is recognized and that they receive the restitution they are due? It is also necessary to ensure that the offender realizes the damage caused by the offense and pays the debt owed to the victim as well as society. That second sentence sounds very rehabilitative to me, which is a purpose of punishment.
And that's exactly the second part of the syllogism I wanted to get to. In 89 Firearms, one of this court's cases in this area, the court said that the inquiry is whether the remedy is more remedial than punitive. In both Paroline, which is one of my opponent's favorite cases, and Dolan, this court said the primary purpose of restitution is remedial. If you put those two things together, if the question is whether it's more remedial than punitive, and this got to a lot of the questions that Justice Alito was asking to my friends on the other side, clearly this compensatory tort-like system is more remedial than punitive. It's designed to get victims compensation. The last thing I'd say about that, Justice Jackson, is this court has repeatedly recognized that virtually any monetary exaction or other sanction, whether civil or not, has a deterrent effect, just like the tort system has a deterrent effect. When you get I'm sorry, Justice Gorsuch.
No, please finish your—
I mean, just like the tort system has a deterrent effect. That's a big purpose of the tort system, is to deter tortfeasors from doing torts. But that doesn't make it punitive. And so if the only deterrent effect that arises from a monetary exaction is the deterrent effect that any form of compensation would have on the relevant behavior, then that's not enough to shift the balance from remedial to punitive. Justice Gorsuch, I'm sorry.
I just wanted to give you an alternative hypothesis about the shift between the VWPA and the MVRA going from more discretionary amounts to a mandatory amount. Could Congress have thought, yeah, this is punishment for sure. It's punishment for all the reasons your friends on the other side say, and all the courts of appeals concluded with respect to the VWPA. But district courts are simply not exercising their discretion appropriately, and we're going to take that discretion away. In much the same way that sometimes Congress takes discretion in sentencing prison terms away and creates mandatory minimums. Thoughts?
Well, I think it's conceivable that Congress could have had that intent, but at least in terms of the legislative history of the MVRA, nothing like that is shown.
How about the MVRA? Isn't it pretty clear that was what was going on?
I think what's in the MVRA?
Yeah, Congress thought that discretion needed to be taken, more discretion had to be taken away.
Oh, no, Justice Gorsuch. I think what Congress looked at was an epidemic of hospitalizations and fraud, wiping out people's life savings, and it being too hard for victims to get the compensation they needed.
Okay, all right. And that the awards were not appropriate and they needed to be more severe.
But, well, you know, they needed to be more compensatory.
Okay.
And as I said, in cases like Marcus versus Hess and Helverine versus Mitchell, the compensatory nature of a remedy has been the lodestar
it could be
for
more
rendering it non-punitive.
It could be more compensatory or it could be more punitive, couldn't it?
Well, again, I go back to this court's precedents. This court has said that compensatory remedies, even treble damages that operate...
I understand that in the civil context, but I am asking you to spot a lot. And I'm asking you to spot that, you know, the circuits were not completely crazy in thinking that the VWPA was punitive. And if that's true, then maybe that's really the source of our disagreement, or at least in this colloquy.
I understand the intuition, Justice Gorsuch, that, well, when you make something mandatory, doesn't that make it more severe
I guess
and so more
thank
punitive?
you, Mr. Bash.
But
you stated my question better than I did.
But I don't think that ultimately holds up, because it is the tort system that is a mandatory compensation regime. It is the civil justice system that is a mandatory compensation regime.
There's compensatory in both cases before, just an insufficient one, and Congress made it more punitive, more compensatory.
It really wasn't. It was capped at compensation, but it empowered judges to say, how do I impose an appropriate punishment on this person by calibrating the amount of restitution in connection with all the other things I'm going to impose at sentencing. So it was really more of a criminal system.
I understand your point.
As I understand your argument, Mr. Bash, you're saying, well, look, this is compensatory. Here are all the ways we can see that it's compensatory. But I think the opposite argument is that just doesn't get you home, because a compensatory system can have punitive, it can be part of a punishment scheme. And indeed, there's a theory behind this, right, which is you're forcing the defendant to confront the nature and the extent of the harm that he's committed, and that is a powerful way of driving home his wrongdoing. So, you know, to say it's compensation, it's like, okay, it's compensation, but compensation can be a form of punishment.
Well, Justice Kagan, I don't think we need the rule as broad as all forms of compensation are not punishment. I think that would be open to the court and consistent with its precedents, but I don't think you need to do that. I think you can distinguish the VWPA and the statutes like the one at issue in Kelly that say, in imposing a compensatory remedy, don't just look at victim loss. Look at what's best for this defendant, what's going to promote the purposes of criminal punishment and deterrence and so forth. But when you have a regime that's essentially just a mechanical compensatory regime, I think under this court's precedents like Marcus and Helverine versus Mitchell, that's non-punitive. And I go back to—
I'm wondering why. If the whole idea of the theory is that it's punishment when you force the defendant to confront the extent of his wrongdoing, what better way to do that than to make the restitution scheme entirely focus on the defendant's loss?
Well, Justice Kagan, let me try it this way. I mean, 3664L allows victims to take advantage of the collateral estoppel effect of the criminal judgment in bringing a separate civil suit. So you can imagine a system where the victim, it works exactly the same way as it does here. But the victim just goes under a different case number, maybe even the Attorney General initiates it or maybe not, and just invokes the collateral estoppel effect of the judgment, and everything's the same. It's a compensatory remedy. It's offset by civil judgments, all the same features here that are laser focused on compensation. I think it would be pretty clear that that's a typical civil compensatory statute. And so the question is, does the fact that Congress arguably, and I think it's only arguably, made this part of the sentence or part of sentencing proceedings change things? And I think the government has to admit that that can't be the line, because a lot of civil things are imposed at sentencing through conditions of supervised release. This court hasn't decided that question before, but lower courts have almost uniformly said that DNA testing, these are ex post facto challenges, drug testing, consent to certain forms of searches, those are all civil things imposed at sentencing because they serve non-punitive goals. In those cases, it's preventing reoffense or reintegration into society. In this case, it's compensating for harm in a way that I think is materially indistinguishable from what the tort system could provide.
Except in the tort system, if the victims receive insurance or some other form of compensation, then you wouldn't have the ability to get the complete relief in the context of the proceeding. And I'm not aware here of restitution being offset by other forms of relief received.
It is, Justice Jackson.
It is?
Yes. Under 3664, there's two ways it happens. One, once there's a restitution award and the victim gets a civil judgment for the same harm, it's got to be reduced. So that's
civil judgment.
Right.
But
so
insurance.
Insurance, it's not taken into account in the computation of the award, but then the judge can order that portion of the restitution award go to the insurance company or the other source that either paid it or has a obligation to pay. And the only limit on that is they got to get paid last after all the victims get paid. But it actually is offset.
I mean, I think the argument against you would go back to the way that Ms. Robertson answered Justice Kavanaugh's question, where when Justice Kavanaugh said, what do you want? And Ms. Robertson, listed about 42 different ways in which Congress said that this was criminal punishment. And then you're here to say, yes, but look at this intense focus on the victim's loss. And in the context of those 42 different ways, you're asking us to say, well, the fact focused on the victim's loss takes us out of the criminal punishment box. And I guess what I'm suggesting is that, no, in that context, it's fully consistent with the rest of everything that they did. It's like, yes, it's focused on the victim's loss, but that doesn't make it any less criminal punishment.
I hate to attack the premise of the question, but I don't think there are 42 different ways. Most of the things that my colleagues said I don't think are persuasive at all. So the thing I kept hearing was that they denoted it a penalty. But this court said in 89 firearms that penalties can be either civil or criminal. We've given a ton of examples throughout the U.S. Code where penalty is used in the civil sense or the criminal sense. Sanction is the same way. And in fact, in one of the provisions my friend relies on, the government relies on, 3551, Congress said the sentence is the fine, the imprisonment, and the probation, and the sanction is forfeiture and restitution. Now, there are other provisions they can point to that suggest it's a sentence. I think in reality, Congress was of two minds on this at different points and probably never formed a judgment about whether it is, in theory, part of the sentence. But even if I accepted that it was part of the sentence, I think that just goes back to the point I made before, which is, can Congress fold a clearly remedial compensatory remedy into a sentence for efficiency's sake without either triggering step one of Mendoza-Martinez by signaling an intent that it be punishment or making it have to be punishment at step two, which the government doesn't even argue. So I don't think there are 42 different ways. I think this is overwhelmingly compensatory on almost every metric. And sorry, Justice Alito, I'd look at you, might ask a question.
No, I was going to ask something different, but I'll go ahead since there's silence. The government wants to sail between the Scylla of the Sixth Amendment and the Charybdis of the Seventh Amendment. And it seems to think that it can escape the Seventh Amendment by listing 42 things that would be inapplicable in any other situation. But either of those would destroy this regime, probably. So why should which one is more dangerous?
The Sixth Amendment is by far more dangerous. Let me give you a quick pitch on the dig, though, for that, which is that this is the lurking issue that actually really matters here, and the parties have barely briefed it. The actual question presented is vanishingly unimportant for people who were committed the crime before April 1996, were convicted after. For some reason, the court applied the MVRA, even though the government was saying to apply the VWPA, and they still have an outstanding award. So the actual QP is not very important. As you say, though, the jury trial question could destroy the whole regime. So under the Sixth Amendment, the Apprendi rule, as elaborated on in Southern Union, says any fact necessary to increase the maximum monetary award, I'm going to sub in monetary award, but the court has applied that to fines, requires a jury trial. Lower courts have said in this context that, well, the conviction authorizes the maximum unlimited amount of restitution. As Justice Gorsuch pointed out in a separate opinion in Hester, I mean, that just does not follow logically. Under 3664E, the court
Thank you, Mr. Bash.
Under 3664E, the court has to find by a preponderance of the evidence that particular items of loss have been proved. Clearly, that's fact-finding. For any non-zero amount of restitution, the Apprendi rule would obviously require a jury trial. Of course, the court could always draw exceptions to it. Justice Alito, in the same case, you suggested maybe just kind of drawing a line there, but the Apprendi rule clearly applies under the Sixth Amendment. The Seventh Amendment is much closer to me. So on the original understanding of the Seventh Amendment and its plain text, it says suits at common law. So I think pretty clearly this is not a suit at common law. It's a statutory restitution proceeding. Of course, this
this court has said, Mr. Bash, as you are well aware, maybe about to say, and
I'm not going to stop there,
apologize.
Justice Gorsuch. I got more riffs on that.
I'm sure you do. I know. But the
court
court has said, labels don't matter. And if it's in substance a civil trial for restitution, that would have been a suit at common law. Surely, wouldn't you agree?
So what this court has said is that statutory causes of action that mimic common law causes of action both in substance and in remedy, meaning the Beacon Theater's damages, equitable distinction, trigger the Seventh Amendment right. So let's just accept that the court would not reconsider that. This is not quite a statutory cause of action. It is sort of an unusual proceeding, although the one that had a history behind it at common law, as I think your opinion pointed out. But here's what I think is the important point. This court has been much more context dependent on whether the remedy phase of a civil trial requires a jury finding. So the two cases are Tull versus United States and Feltner versus Columbia Pictures. In Tull, the court said, this was in a footnote, but the majority said, we see nothing in the Seventh Amendment that requires a jury trial for the remedy phase. And that was a civil penalty where it was very discretionary. In Feltner, 9 years later, copyright damages, the court said that requires a jury trial. But part of that was based on the unique history of the Copyright Act. So all I'm saying is I think there would be historical work to do under the Seventh Amendment. The Sixth Amendment, unless this court really drew a kind of outlier exception to Apprendi, I think the Sixth Amendment case is pretty open and shut under Southern Union.
Isn't that interesting that here you're making an argument that the government has miscalculated its own interest in choosing to take the risk with the Sixth rather than the Seventh?
It does that sometimes. And frankly, I think that
the government's made its bed. Why should we let them lie in it, Mr. Bash?
Well, there is a path-dependent reason, I think, for that, which is that the government developed this position pre-Apprendi. And so it developed this position that restitution is criminal. I'm reading between the lines.
It made the opposite argument in the Eighth Circuit, and here we are. It's flipped its view.
Yeah, I think maybe the U.S. Attorney's Office there didn't follow the DOJ position overall.
And it's admirable that the DOJ flipped its view, I want to say. I think it is admirable that they reconsidered their position, but they've made their judgment.
And all I'm saying with respect to their analysis of the jury trial right is that they developed that position pre-Apprendi, I think, precisely in order to avoid the Seventh Amendment problem. The problem now is, I think, arguably the bigger constitutional problem is the Sixth Amendment. And I didn't hear, in response to Justice Kavanaugh's question, a very satisfactory explanation of what the court would say in this opinion to avoid the Sixth Amendment problem.
Thank you.
But that's unavoidable.
Go ahead.
I'm sorry. That's unavoidable. In the civil context, at least at common law, I believe that restitution was not an equity, was it? Claim, or was it a common law jury claim?
So, Justice Sotomayor, this depends a little bit on shifting meanings of the word restitution, and I agree with Petitioner who points this out in her brief, or his brief, counsel's brief. Restitution is a word for an equitable remedy that I think would fall on the Beacon Theater's bench trial side of the line when you're talking about restoring something taken. And some of the remedies under restitution take that form. So if someone steals your car, restitution might have to be to return the car. I think that actually would fall on the Beacon Theater's line of you don't need a jury trial.
But this is different. This is paying a monetary
some of the forms of restitution, the majority in the statute here, are really traditional damages.
So
forms.
really, jury trials would have been required in the common law. If we required them in the criminal context because it's a substitution for civil, wouldn't be the end of the world, Counselor. It would just be avoiding taking away a right to a jury trial.
I don't think it would be end of the world as a practical matter. It would mean the entire statutory scheme has been unconstitutional for decades because they haven't been provided jury trials. I don't think practically it couldn't be implemented. But as I said, I think the Sixth Amendment problem is much clearer.
Well, this would be a new rule because we pretty much have established precedent to the contrary. Thank you, Mr.
I do think there would be an argument under the Seventh Amendment that this could survive under the reasoning of...
So you're not buying their footnote 3 in the government's brief then on the Sixth Amendment? Yeah. Where they...
the government, I think, if I'm remembering the footnote, rehashed the Court of Appeals views.
Correct.
The judgment of conviction authorizes unlimited restitution. That is just not true. There has to be a finding of particular items of loss. That is a factual finding that you can't, that without which no restitution is authorized. So it's just not correct. I don't see how that, a lot of Court of Appeals have adopted that view, but I don't think it is correct.
Justice Thomas, anything further? Justice Alito?
I can't help myself. You'd agree that in the civil context and Seventh Amendment, when you're seeking damages, you usually get a jury trial.
That has been the court so held in the copyright context in Feltner. I don't know the court has.
And here, nobody's asking for the return of the horse. They're seeking damages, right? Effectively. That's your view. There's full compensation.
Yeah, I don't think there's a distinction between many of the heads of loss here and legal damages. I think that's true.
Okay.
The only point I was making is that under Tull and Feltner, I think there's a more nuanced analysis on whether the remedy phase of a civil jury trial, that phase of it requires a jury, because it held for civil penalties at least that it did not.
Gotcha.
That's different than damages, I know.
Gotcha. Thank you.
Okay, Justice Jackson. Thank you, counsel. Ms. Saharia?
Just very briefly, I'd like to respond to Justice Alito's question about the findings and purposes of the VWPA that he posed to the government. If you look at Section 2 of the VWPA, it is replete with references to the criminal justice system and the criminal justice process. Congress was intending to give victims more of a role in the criminal justice system, but there's nothing in those findings or purposes that suggests that Congress thought it was creating a civil proceeding, which is a relevant question here. Second, with respect to the Sixth Amendment and Seventh Amendment question, I'll just say the following. First, I think under the Seventh Amendment, this case is much more like Feltner than Tull because it involves compensatory damages. And what's more, the inquiries that judges make at sentencing really go to core liability type questions of proximate causation. To determine who is a victim, the court has to determine who suffered losses proximately caused by the offense conduct. Those are the kinds of questions that in the civil context, juries always decide. And if the court's going to pick which one is worse, well, a ruling that restitution is civil would completely upset the apple cart on the Seventh Amendment because the circuits rejected that argument uniformly on the ground that restitution is criminal punishment. In the Sixth Amendment context, the courts, again, have uniformly rejected the Apprendi argument, but they've done so on two different grounds. Only a minority of courts have adopted the civil remedy ground, and all of the courts have said that it's an indeterminate range that just isn't subject to Apprendi. That may or may not be correct, but that would be an issue for the court to address in some future case if it so chose. And then finally, on the point about restitution being mandatory under the MVRA, I would adopt Justice Gorsuch's response to that, which I thought was quite was correct, that Congress simply made the relevant judgment for sentencing courts and making restitution mandatory. And I think that the argument that restitution is civil because it's mandatory doesn't account for the way that Congress intertwined restitution with all of the other punishments imposed at sentencing. So for all those reasons, we ask the court to vacate and remand.
Thank you, counsel. Mr. Bash, this court appointed you to brief and argue this case as an amicus curiae in support of the judgment below. You have ably discharged that responsibility, for which we are grateful. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.